Good morning. Good morning. All right. And for those of you out there in TV land, good morning too. And you can shout back at your screen if you wish. I'm the chair of the United States Sentencing Commission, Carlton W. Reeves, and I welcome you all to this hearing. I thank each of you for joining us, whether you're in this room with us or attending via live stream. I have the honor of opening this hearing with my friends and fellow commissioners. To my left, we have Vice Chair Claire Murray, Vice Chair Laura Mate, and Commissioner Candace Wong. To my right, we have Vice Chair Louis Felipe Restrepo, Commissioner Claria Boone, and Commissioner John Gleason is not present in the room, but he will be attending by phone, and he'll hopefully we'll have his presence here this afternoon. We're also joined by ex officio commissioner on the end there, Commissioner Jonathan Wroblewski. I want to thank all of my fellow commissioners for their extensive contributions, their spirit of collaboration, and their dedication to our work. I'm honored to be sitting among such esteemed colleagues and friends. We are also joined by commission employees, some of whom are in this room, many of whom are not. They've done the research, they've drafted the policies, they have set up this room, and they have done so much more to make this hearing possible. And I thank each of them. On behalf of the commissioners and the public, I thank all of our agency staff for the amazing work that they do every day. We value your public service. When preparing these remarks, I thought about what Congress said is the Commission's most important mission: to establish sentencing policies and practices for the federal criminal justice system that meet specific criteria. Our policies must provide certainty and fairness in sentencing, including by avoiding unwarranted sentencing disparities. And our policies are supposed to reflect advancement in knowledge of human behavior as it relates to criminal justice process. The purpose of today's hearing speaks to our core mission of crafting sentencing policy that is fair and evidence-based. In May, we unanimously voted to create policies that will change how criminal history affects the sentences of defendants. Reflecting the latest research on effective criminal justice practices, these policies will ensure defendants receive more just and evidence-based sentences in the years to come. Now, we must decide whether people incarcerated under the old policies should get a chance to have their sentences revised in line with our new one. In other words, today's testimony will help us decide whether to apply our criminal history amendments to the sentencing guidelines retroactively. Congress has told us to make this decision by examining a wide spectrum of views. To that end, we asked the public to provide us with their input. We received hundreds of comments from senators, judges, lawyers, religious leaders, doctors, professors, advocates, victims, families, concerned citizens, and incarcerated people. Those comments are posted on our website, as are the videos and transcripts of the hearings we conducted on these amendments. I encourage you, members of the public, to read these comments and watch our prior hearings. When those persons spoke to the commission, they were heard. We heard them say this decision on retroactivity is our chance to correct past wrongs and address the systemic disparities that have plagued our society for far too long. We heard them say our decisions must weigh the needs of victims and survivors. And we heard them say our decision can inject hope into the lives of those whom will be eligible. Today, these comments will be buttressed by testimony from a distinguished group of individuals. To all who are speaking with us today, I promise that your extensive journeys and preparations will be worth it. When you speak to the commission, you will be heard, and you will be read too, as your testimony will be available for the public to access on our website, www.ussc.gov. Finally, I want to give our witnesses and the public some insight into how we commissioners will make our decisions about retroactivity. Many of the witnesses speaking today will talk about the costs of any decision we make. Let me reassure you, we take pains to consider all these costs. We consider the time judges and their staffs will have to expend dealing with filings for reduced sentences. We consider the additional resources expended on reentry and supervision. But we also consider the financial costs of continuing to incarcerate someone, which stands at roughly $44,000 per person per year with the BOP, which is $40,000 more than the annual cost of supervision, and which also increases year after year after year. And we consider a cost that has little to do with docket sizes or dollars and cents. The moral price of incarcerating someone for longer than is necessary, for longer than is just. As my former colleague, Judge George Hazel, so aptly put it, liberty is the norm. Every moment of incarceration should be justified. Whatever decision the commission makes on retroactivity, I promise it will reflect every cost, every benefit, and every perspective we hear about today. Panelists, you will each have 5 minutes to speak. We will have read your written submissions. And to the members of the public, those who are watching, I encourage you to read that testimony. Again, it is on the website. Read their statements. Those statements are on the website. And again, at www.ussc.gov. I implore you to read these documents, to read this information. In addition to the statements that are posted, I remind you that the public comments are also posted. They're posted there on the website. We have also performed an impact analysis on the retroactive application of parts A and B of the 2023 criminal history amendments. It is on the website. Please read it. Also, this is directed to the public again. If you would like to receive updates on future events of this commission or other commission or all of our commission activities, visit us on Twitter. Unless you get that message that says rate limit exceeded, visit us there on Twitter or contact us directly. You may subscribe to our email and receive email updates. Any questions, You may present to us via email, pubaffairs, PUBAFFAIRS @USSC.gov, or you may call us 202-502-4597. Now, returning to our panelists, your time will begin when the light turns green. You have 1 minute left when it turns yellow, and no time left when it turns red. If I cut you off, please understand I'm not being rude, as we have so much to cover today and a limited time to hear from everyone. For our audio system to work, you would need to speak closely into the microphones. And the weather isn't the only thing that's hot. It's not as hot as it was yesterday, I don't think, because we got a little rain. But it's been hot all over here, but these mics are even hotter. So please make sure you understand that these mics are hot, so be warned. Well, again, when you speak to the commission, you will be heard, but you're likely to be heard by everyone in America. So just be careful. When all the panelists have finished speaking, the commissioners may ask each of you questions. I'm certain we will do so. Thank you for joining us, and I look forward to a very productive hearing. Our first panel is made up of, and I'd like to introduce our first panelists, who will present the executive branch's perspective on retroactivity. We have with us the Honorable Kevin G. Ritz, who serves as the United States Attorney for the Western District of Tennessee. He's close enough to be my homeboy. He's in Memphis. Mr. Ritz was previously an Assistant United States Attorney in the Western District of Tennessee for 17 years. He has held various leadership positions in the office, including serving as appellate chief and special counsel for over a decade. Mr. Ritz has twice served on the Department of Justice's Appellate Chiefs Working Group. Mr. Ritz, when you are ready, we are ready when you are, sir. Thank you.
Good morning, Honorable Chair Reeves, Vice Chairs, and Commissioners. My name is Kevin Ritz, and I serve as the United States Attorney for the Western District of Tennessee. Thank you for the chance to discuss the Department's views on retroactive application of Parts A and B of the Criminal History Amendment. The Department understands the Commission's interest in leniency for first-time offenders and appreciates the concerns animating the status point amendment, but we oppose retroactivity of both parts. When evaluating retroactivity, the guidelines instruct the Commission to consider the purpose, the magnitude of the change, and the difficulty of retroactive application. Each of these factors counsels against retroactivity here. The Commission has traditionally viewed retroactivity as the exception and not the rule. This is because finality in judgments is essential to the operation of our criminal justice system, ensuring justice for victims and defendants. Historically, the Commission has reserved retroactivity for amendments that strive to correct a systemic wrong, and we have supported it in those instances, including the 2011 amendment that reduced crack cocaine penalties. But this criminal history amendment does not correct systemic failures. It instead facilitates efficient guideline operation, reflects recent Commission studies on recidivism, and accounts for variances in departure rates. The amendment results in a minor downward adjustment that Congress did not intend for retroactive application. These factors weighed against retroactivity of the recency amendments in 2010, and they do so again here. Congress also recognized that evaluating retroactivity involves balancing the burden on the courts and the magnitude of the change. Here, the magnitude of the change is small. While any sentencing reduction is significant to the person serving that sentence, the status point amendment at best would result in one criminal history category reduction, which is generally equivalent to a one offense level reduction. That's the smallest the Commission can make via an amendment. The 0-point offenders amendment similarly has a minor effect, resulting in a 2 offense level reduction. Thus, the magnitude of the change is small, and retroactivity would contravene congressional intent and commission precedent. The burden on the courts and the criminal justice system, on the other hand, would be significant, which is why all the judges who publicly commented on the amendment also oppose retroactivity. The commission estimates that there are potentially more than 85,000 individuals in the Bureau of Prisons who were assigned status points or had 0 points. Past experience has shown that most, if not all, of these individuals will move for a sentence reduction. While the commission estimates that only a fraction may ultimately be eligible, 85,000 defendants is more than half of those who are in custody of the Bureau of Prisons. Processing these motions would more than double the sentencing work done by the system, including prosecutors, courts, defense attorneys, probation, and the BOP in a given year. Additionally, the commission's numbers underestimate the number of potentially eligible defendants. That's because the new exclusionary criteria introduce novel legal concepts that will require additional fact-finding and litigation. Retroactivity here would be, in the words of then Commissioner Howell, administratively burdensome to the point of impracticality. There is also a public safety concern. Defendants with status points have already recidivated while under a prior criminal justice sentence and are likely to recidivate again. The majority are in criminal history categories 4, 5, and 6, and many committed serious or violent crimes. Part B has limiting criteria, but still applies to many serious offenders. It sweeps in public corruption, national security offenses, and serious economic and corporate crimes. The amendment rewards those who violated a position of public trust, and it benefits many white-collar defendants, resulting in greater inequities. Finally, retroactivity poses both operational and reentry concerns. Retroactivity would interrupt transition planning for the BOP and increase burdens on probation. In sum, public safety risks, the purpose of the amendment, the limited magnitude of the changes, the significant burden on the system, and the Commission's own precedent all counsel against retroactive application of these amendments. The Department appreciates the opportunity to provide our view and looks forward to continuing our work with you. I look forward to your questions.
Thank you, Mr. Ritz. I turn to my colleagues. I open the door to anyone who wants to jump in first.
May I? Mr. Ritz, one of the other commenters that favored retroactivity noted that districts already have systems in place for handling post-conviction matters, including U.S. attorneys' offices. I was wondering if, from the department's perspective, having estimated that close to 85,000 inmates may potentially move for relief should this be made retroactive, whether you think as a U.S. attorney that you already have sufficient staffing or resources devoted to handling that burden, and if not, whether you foresee some kind of increase in support staff or prosecutors.
We do not have it on hand, and I came to this role after being appellate chief for 12 years and managed our response to prior amendment cycles. It's safe to say we created ad hoc systems in each of those circumstances. I think that's fair to say, at least in our district, the same happened for the probation office and our public defender's office as well. I don't anticipate, at least it didn't happen before, that we'd get additional resources. The last time these things happened, we diverted other resources to this task, this very important task of sorting through these motions and figuring out who was eligible and whether a reduction was warranted. I happen to think our AUSAs are doing important work, and so that is a significant burden on us. I guess what I would also say is it's a significant burden on the system, and we do think the right number to focus on and to be clear-eyed about is the 85,000 number. And our experience, past experience, taught us that any individual in this circumstance with status points or 0-point offenders is going to move. And I think no one in this room would begrudge those individuals for filing a motion and seeing what happened, right? And seeing how the system worked it through. But it's a big burden. We did it in the past. Frankly, I'm proud of how we handled these things in the past. And I could speak for other U.S. attorneys around the country. We did a good job. And that's we, not just us, but our public defender colleagues, our probation office, court staff, BOP. We did what it took, but the fact that it happened before does not mean that it was not a significant burden and would not be
Thanks, Mr. Ritz. In your papers, the department's fallback position is that if we do vote in favor of retroactivity, that we delay implementation for 9 months. And I'm interested in how you arrived at that number. In the past, we've sometimes delayed for 6 months, sometimes for a year. Was there a magic to 9 months here?
I don't think there was a magic, Commissioner, but it was certainly a result of the decision-making process, which folded in the views of the various department components. The department contains multitudes and a multitude of viewpoints, and BOP was a piece of that, and it's safe to say BOP had concerns about how much time it would take to run up and to implement this. Usually their processes start about 180 days before a release date. There's a shortage, as I understand it, and there's already a strain on reentry and transitional housing resources. So short answer, there's no magic, but we did consider 6 months, we did consider a year, landed on 9 months as what we thought would be a fairly comfortable time period. But it is a fallback position.
Let me ask you, you've been in the U.S. Attorney's Office 17 years, so you've seen the past retroactive amendments, and you indicated that you all did ad hoc sort of ways in which dealing with prior retroactivity procedures. Could you tell me what your district specifically did to accommodate the drugs -2 and the other crack retroactive?
Yes, Commissioner, it was essentially we did, and this is just us, we're a medium-sized office, and we had one AUSA who essentially dedicated to that full-time for a matter of not weeks, but months. And then many other AUSAs picked up cases, especially if they were their cases originally. What we run into, and all the various ways in which we've been revisiting criminal justice federal sentences over the past several years, is a lot of times it's a brand new group of people that are picking these cases up. It's a different judge, certainly different AUSA, different defense attorney. And so that kind of builds in a piece of the burden. But essentially, I think the public defenders also did the same, the probation office did the same in our district, kind of had a point of contact, and those people went through case by case. I will say one aspect of it that I'm not sure is reflected in the papers that have been presented to this commission is, yes, the public defenders played a role in our district and did an excellent job, as they always do, but the cases that they handled, at least for our district, were the cases on the list, essentially the list that was provided of who might be eligible, and so they would enter a notice for those cases. What we saw and what the court saw were the whole pie, and that included pro se motions by offenders that were not on that list, but thought maybe they would move for relief, and maybe they had a good faith basis for thinking that. Trying to think if there was another aspect of that, Commissioner. I would say BOP was involved. We usually always get the BOP records. That takes some time to kind of see how this individual has spent their time in custody. And I guess the last point I'll say about that process, which I'm also not sure is reflected in the submissions, is it actually can be difficult to recreate or create for the first time a sentencing record. If there was no appeal, for example, there's typically not going to be a sentencing transcript. So there's a little bit of time and effort that goes into that and trying to figure those things out. And so that's an aspect that I hope that's responsive in describing how our district handled it.
You would agree, though, that the pre-sentence report actually would be a good reference point and a starting point on analyzing anything about the conduct of the defendant during the course of the crime.
100%, Commissioner, and the pre-sentence report, along with the statement of the reasons, is the starting point. It was often not the ending point, and I think that's fair to say.
Thank you.
Good morning, and thank you for your submission. I'm your neighbor as well, just your neighbor to the north. My question goes to the burden argument, and I was curious about the department's position. The department believes just about every one of the folks of the 85,000 who meet some parts of the criteria, but all of them will file motions. Other panelists who we've heard from or will hear from later today argue that in the past, only about 20 to 30% of all the motions that are filed are by folks who are ineligible. And so I would like for you to sort of speak to that and then explain why you think in this situation it would be closer to 85,000.
I would say first, that was not our experience. And I think the numbers bear it out that it would be more than 20, 30%, maybe not on drugs -2, but on some of the other cycles. I don't have those precise numbers in front of me. I can just tell you, in our experience, we dealt with a large portion of people who ended up not being eligible but moved. And I think, again, I want to be clear, I don't think we or anyone here would begrudge an individual with status points or who had 0 points filing a motion. And I think that's another piece of this that might be a little different is it's actually a little hard. It's a little less mechanical than the drugs -2. It's a little more involved to understand, okay, if you're eligible, would that actually affect, would the decrease in criminal history points affect the criminal history category? It would not always affect that because sometimes it would just mean you're just still in the same category. There is also, and we ran into this the last couple of cycles as well, situations like the career offender enhancement that comes into play, and so you have to sort out whether that is what set the offense level or the criminal history category as opposed to the circumstances of the offense. So I hope that's responsive.
Vice Chair Murray?
So I know in 2011, the department advocated for some carve-outs for people, offenders with gun enhancements, for example. You haven't advocated as even a fallback position here for carve-outs. Are there carve-outs that would mitigate some of the department's concerns about public safety? I know, for example, retroactivity of status points would put over 1,100 firearms offenders back on the streets in the first year. Are there carve-outs that are particularly concerning to you that we should consider?
We have not, our official position is it should not be made retroactive. We have not adopted a fallback position on that front on the dimension of whether retroactivity should be limited to only certain offenders. I will say we do highlight in our materials, and I'll highlight here that there are a lot of violent offenders that are swept in here. The firearms offenders, robbery, there's also child exploitation, child pornography offenses that are swept in. And then on the Part B side, as we said, national security offenses, offenses committed by people who abused a position of trust. So those are particularly concerning. We flag them as reasons for non-retroactivity as a general sense. I guess in a very, very high level, and I don't want to speak out of school, out of what I'm authorized to say, we're against retroactivity. So if there was a spectrum between non-retroactivity and full retroactivity, and there was somewhere in between, then we'd prefer that than to the full retroactivity.
I wonder if we might take advantage of your experience as a former appellate litigator, but are there, you described some of the application here as less mechanical than some changes in the past. I'm wondering if there are follow-on legal issues that you could foresee where the change involves a change to criminal history category as opposed to sort of a reduction in offense level. For instance, with the safety valve,
Yes.
or implicating, as you know, there's currently a circuit split on the application of the safety valve.
Right.
And just if you have sort of a crystal ball here on some of the legal issues that could be litigated.
I appreciate the question. I would say the safety valve is a great example. The probation officer's submission here flagged that, and I thought that was appropriate to flag that the reduction in criminal history points might lead to the safety valve coming into play in a way that it was not considered at the initial sentencing. And then, as we all know, there are lots of other aspects to the safety valve that would then need to be considered. I think that's a complicating factor that is easy to foresee if Part A would be made retroactive. Another is that career offender issue that I flagged. As we all know, the career offender provision itself has been a moving target for the last 10 or 15 years, crime of violence, controlled substance offense. We definitely ran in the last time to situations where we were arguing, litigating over, well, do we consider whether the career offender provision is still applicable or not, right, for a drug offender, for example. And I guess the last thing I'd say, or two more things. One is, the appellate piece of this, I would like to flag before my time expires, because it is not just a burden. Retroactivity imposes not just a burden on the district courts, it's a burden on the appellate courts. And I'm in a circuit where every appeal from one of these motions, or one of the adjudication of these motions, requires full briefing. And as we all know, the courts of appeals saw lots of litigation, even on the past fairly mechanical drugs -2 and the prior amendments. Lots of litigation. There were actually Supreme Court cases, as we know, about these issues. So sometimes they're foreseeable and sometimes they're not. Last thing I'll say is on Part B, and we've made this, I think, clear in our materials, we're very concerned about some of the exclusionary criteria that are set out in Part B, that there's going to be extensive litigation over those criteria, some of which are kind of new phrases to understand and litigate and interpret.
Anyone else has? I'll ask one other question then, since we have this time. Irrespective of, I guess one of the things that I've sort of expressed to others in other comments, courts have to deal with filings that are made every day in every situation. The keys of the courthouse are open, and there's nothing to stop people from filing cases that have merit, nothing to stop them from filing meritless cases, and certainly nothing stops an appeal from going forward. So how can we account for that? Should we be concerned about this increase of cases that might be filed when they can be filed anyway, whether?
Yes, is a short. You can be and you should be, and it's not just because the department's saying so, but it's because that's one of the three key factors that the commission's commentary says to consider, is the burden and the difficulty on the system. And so it is a significant burden, and we do believe that 85,000 is the right number to focus on, as opposed to the much smaller numbers of people who might be eligible at the end of the day. And so I think that's how I would respond to that.
Okay. Thank you, sir. I appreciate it. Any other questions from Mr. Ritz? Well, thank you, sir, for your testimony. We certainly appreciate you. Hope you have a safe trip back.
Thank you so much. Thank you.
All right. Our second panel, ladies and gentlemen, provides us with the perspective of criminal law practitioners on this issue. First, and I hope I do not butcher your name, I hope so. We have Sapna Merchandani, thank you, who serves as an assistant public defender in the District of Maryland. There she handles appeals to the Fourth Circuit Court of Appeals. Over the past 15 years, she has managed the office's retroactive sentencing projects, including for amendments that reduce the base offense level for crack cocaine offenses, gave retroactive effect to the Fair Sentencing Act guidelines, and reduced the base offense level for all drug offenses. Second, we have Patrick Nash, who serves as vice chair of the Commission's Practitioners Advisory Group. With 30-plus years of legal experience, his practice focuses on complex criminal defense with particular emphasis on federal matters. Mr. Nash is the current coordinator of all attorneys in the Eastern District of Kentucky who contract with the court to provide defense services for indigent defendants. Over the years, he has served on a wide variety of criminal law-related committees, such as the United States Courts Defender Services Advisory Group, the United States Court of Appeals for the Sixth Circuit Advisory Committee on Local Rules, and the Sixth Circuit's Committee on Pattern Criminal Jury Instructions. Finally, we have Steve Wasserman, who serves as president of the National Association of Assistant United States Attorneys. The association represents more than 6,000 federal prosecutors and civil attorneys across the country. Mr. Wasserman serves as an assistant United States attorney in the District of Columbia, where he has spent the last 13 years prosecuting violent and drug-related offenses. Ms. Chandani, thank you, I'm sorry. We are ready to hear from you.
Thank you, Chair Reeves, co-chairs, and commissioners. On behalf of federal public and community defenders, we support applying the 2023 Criminal History Amendment retroactively, and we ask that you do so without delay.
I'm sorry, could you bring your mic a little closer and speak up? We want to make sure everyone hears your thought-provoking words.
Okay. I've worked as an assistant federal public defender in the District of Maryland for nearly 2 decades, where I've managed my office's retroactivity work on Amendment 706, 750, and 782. Thanks to the Commission's bold action in making those amendments retroactive, we helped secure reduced terms for hundreds of people serving unduly harsh sentences. My former clients have been extremely grateful for the second chance, and they have flourished. This afternoon, you will get to hear from one of them. Bernard Gibson Jr. had no criminal history, yet in 1997, he received a 27-year sentence for a nonviolent drug offense. Fortunately, through Drugs -2, his term was reduced to 22 years. Like the drug amendment, Drug -2, this year's criminal history amendment is the result of the Commission's diligent and data-driven work. The data showed that 2 metrics used to compute criminal history scores over the last 35 years was flawed due to the original Commission's assumptions about recidivism that have been proven not true. With the empirical evidence in hand, the Commission fixed the guidelines. Now it has the power and the opportunity to allow courts to take a second look at cases where the flawed guideline formed the basis for sentencing. Turning to those cases, I have to admit that when I saw the demographics of who will qualify for retroactive relief, it really surprised me, although it shouldn't have. The vast majority of recipients are Black and Hispanic. The racial disparities are striking and look very similar to those that existed when the Commission retroactively applied Drugs -2. Even though the criminal history guideline, like the drug guideline, was neutral on its face. It's a reflection of the profound unfairness of our criminal justice system, where communities of color have borne the brunt of over-policing and unduly harsh punishments. Retroactive application of the criminal history amendment would be one small step toward restoring a sense of fairness to the system. In my opinion, we owe that not only to the more than 18,000 people already serving unduly long terms, but to their children, their partners, their parents, and their communities, all of whom suffer in their absence. Retroactivity will temporarily result in additional work, but it is manageable and it is worth the effort. We have learned valuable lessons through each of the 3 prior retroactivity cycles. We know how to prioritize motions, we know how to efficiently resolve cases, and we often do so collaboratively with prosecutors. And we've already completed much, much larger projects, including Drugs -2. Compared to that, we know that 2/3 of all districts dealing with retroactivity will have fewer than 200 cases each, which is very small in the big scheme of things. We ask that the Commission not impose any delay in making the amendment retroactive. Considering the magnitude of relief, which will be around 14 or 15 months, even a short delay would eat away at valuable time our clients could be spending in their communities. The formerly incarcerated witnesses who testify this afternoon will attest that that is not minor time. It is real time, and as Chair Reeves said earlier in his opening remarks, liberty is the norm. So even a single day of incarceration beyond what is necessary violates the letter and spirit of 3553A. Plus, based on my personal experience managing 3 projects over the last 15 years, the delay is not needed. We are in a very different place today than we were during those cycles. We have noticed a shift in the BOP's release planning, possibly as a result of the First Step Act. But now my clients are generally asked to submit release plans roughly 18 months before release. Previously, with the drug amendments, they started release planning 6 months before release. But now it's 18 months, and the additional lead time with the previous amendments was needed so that probation officers could approve release plans, provide transitional services. But today, with the longer pipeline of release, those steps have already been completed, are likely to have already been completed more than a year before release. And we can begin preparations now during the 3.5-month period before, that's already built in before the amendment goes into effect November 1st. In closing, the Commission's data shows us that some guideline ranges were tainted by false assumptions about recidivism, and that the impact of those harsher terms landed predominantly on Black and Hispanic individuals. Federal defenders urge the Commission to use its authority to fix the errors retroactively and without delay. I'm grateful for the opportunity to share defenders' views with the Commission, and I welcome any questions.
Thank you.
Thank you.
Mr. Nash.
Good morning. May it please the Commission and my fellow panelists. My name is Patrick Nash. I'm from Lexington, Kentucky, and I'm the Vice Chair of the Practitioners Advisory Group. Our group consists of 1 practitioner from each of the 12 circuits. We also have 3 at-large members and a chair and a vice chair. So there's 17 of us on our group. And it is our position and our recommendation that both parts A and B be applied retroactively by this commission. Above all, we believe that this is a matter of fairness. We have numerous individuals who have received potentially greater than necessary sentences because of status points, overly lengthy sentences because they were in fact 0-point offenders. And in each of these situations, we believe that allowing district courts to have the opportunity to correct these sentences is fair, and it allows them to fully comply with the very first directive of Section 3553, which is to impose a sentence that is sufficient, of course, but not greater than necessary. It's also a matter of fairness because retroactive application of these guidelines would promote respect for the law and respect for our criminal justice system. As practitioners, all too often we realize that our clients and their families have a very low opinion of the system and have a very low opinion of how the criminal justice system works. But this is an opportunity. It's an opportunity for this commission to demonstrate that when we find a problem, we fix it. And we fix it for everyone. We don't just fix it for those who had the good fortune to have their cases come at the right time. And we also fix it even if it means some additional work. Leaving behind between 18,000 and 19,000 people who may have overly lengthy sentences will not engender respect for our system. But applying this retroactively and working hard to do so, that will serve to increase confidence in the system and increase confidence and respect for the law. But perhaps most fundamentally, this is an opportunity for the Commission to have a real positive impact on thousands of lives. And not just the thousands of lives of the individuals who are incarcerated, who can potentially adjust their sentences, but the thousands upon thousands of lives of their family members and their loved ones. All of these people, because of fairness, will have the chance to restart their lives, rebuild their lives, and rebuild their families. As to the magnitude of the change, our group feels like it's right in the sweet spot. It's not too large of a group to be unmanageable. The numbers we're talking about here, between 18,000 and 19,000 individuals who will be eligible for retroactive application, those numbers are in line with previous amendments that were retroactive. but it's also not so small of a group as to be minor. And the extent of the potential reduction, the average reduction being between 14 and 15 months potentially, is also not minor, but is significant. And it's a significant change for those people that are impacted. As for the difficulty of application, this will take some work, but it's not an overwhelming amount of work. And us practitioners, whether we be private attorneys or whether we be appointed under the Criminal Justice Act, we stand ready to shoulder the burden of much of that work. We work and interact closely with our clients. We explain to those clients who are ineligible why they are ineligible. We manage the expectations of the clients who are eligible. We work hand in hand with the United States Attorney's Office and the Probation Office to try to reach consensus where possible. And we streamline our presentations to the court when agreement is not possible. There are almost 19,000 people that will be eligible for reductions. That's a smaller number than some of the previous retroactive amendments. The administrative burden here will be manageable. So for all of these reasons, the 17 members of our group recommend full retroactivity for both Parts A and B.
Thank you, Mr. Nash. Mr. Wasserman.
Good morning, Commissioners. My name is Stephen Wasserman. I'm a current AUSA in Washington, D.C., and I'm here today speaking in my capacity as President of the National Association of Assistant United States Attorneys. It represents the interests of over 6,400 AUSAs working in our 94 U.S. Attorney's offices. My statements made today do not represent the Department of Justice or my U.S. Attorney. It also opposes the proposal to make the Commission's criminal history amendments applicable to status points and zero-point offenders retroactive. These reforms are fundamentally antithetical to the sentencing guidelines' progressive sentencing regime and should not be extended retroactively. The sentencing guidelines are intended to further the basic purposes of criminal punishment, deterrence, incapacitation, just punishment, and rehabilitation. To do this, the introductory commentary to Part A of Chapter 4 makes clear that one of the main purposes of the guidelines is recognizing that, quote, a defendant with a record of prior criminal behavior is more culpable than a first offender and thus deserving of greater punishment. Offenders who have committed new offenses while under a criminal justice sentence are, by definition, recidivists. The underpinnings of the Status Point Amendment and the proposal for retroactive application ignore this reality. Part A eliminates status points entirely for offenders with 6 or less criminal history points. Under Section 4A 1.1a, a prior felony conviction in which the offender is sentenced to more than 1 year of imprisonment results in 3 criminal history points. Thus, under the proposed amendment, an offender could be convicted of 2 3-point felony offenses and receive no status points. This runs counter to the fundamental purpose set forth in Chapter 4 to establish a sentencing regime with escalating consequences for repeat offenders. While the Commission has argued that the status points do not effectively predict likelihood of rearrest, relying on this to significantly curtail use of the status points misunderstands their purpose. In addition to predicting future recidivism, status points acknowledge current recidivist tendencies and provide proportional punishment. In fact, the Sentencing Commission's own impact study established that most offenders who receive status points are in criminal history category 3 before adding status points, and that the average offender who received status points had at least 7 criminal history points before receiving status points, meaning that these offenders fell within criminal history category 4. These are offenders who already had multiple prior criminal convictions counted under Chapter 4 and thus were not timed out. Accordingly, these offenders have already demonstrated that they are recidivists who do not respect the law and are more likely to reoffend. The average sentence imposed on offenders eligible for sentencing reductions with retroactivity also indicates the severity of their criminal conduct. The average sentence of eligible offenders under the Status Points Amendment was 120 months or 10 years. These are offenders who engaged in serious criminal conduct, including over 4,600 offenders convicted of drug trafficking offenses, over 2,300 convicted of firearms offenses, and over 1,300 convicted of robbery. Providing retroactive sentencing adjustments to these offenders will result in more crime and fails to sufficiently recognize the sentencing factors of punishment and deterrence under 18 U.S. Code Section 3553A. Part B, that addresses zero-point offenders, is similarly problematic. This provision creates a windfall to white-collar defendants. Here, too, the average sentence of eligible offenders indicates the severity of the criminal conduct committed by those eligible for the adjustment under the proposal. The average eligible offender received a sentence of 85 months, or 7 years. A significant portion of eligible zero-point offenders have also been convicted of violent and dangerous offenses, including manslaughter, drug trafficking, and sex offenses. Retroactive application of sentencing adjustments to sentences that are not unconstitutional or otherwise patently unjust should be done sparingly. The rule of law relies on finality and predictability. Making sentence adjustments under the criminal history amendments apply retroactively undermines these values. Accordingly, the Sentencing Commission should proceed with caution when making such decisions, particularly where public safety is likely to be negatively impacted. We also have significant concerns that making the amendments retroactive amounts to an unfunded mandate that will impose significant resource constraints on the U.S. Attorney's Office, and our written testimony has more information on those concerns. Thank you for considering NOS's perspective, and I welcome your questions.
Thank you, panelists. I turn to my colleagues, and you can fire your questions at whoever you wish to at any given time. Commissioner Wong?
Ms. Merchandani, I noted that you've worked on retroactivity of sentencing issues for about 15 years, and I wanted to ask you about, I'm sure you're familiar with the Commission's 2010 recency point elimination. As you know, then the Commission did not publish for comment retroactivity or hold a hearing. The Commission voted in 2011 to not make it retroactive. And Justice Ketanji Brown Jackson at the time had stated that the recency amendment was, quote, not intended to address the same types of fairness issues involved in the circumstances where retroactivity typically has been adopted in the past. I'm curious if the study that led to that amendment was very analogous to the study that the Commission relied on in this situation, in that it related to Commission data about the likely predictive value of future recidivism. And I'm curious if you agree that recency points were not intended to address the same types of fairness as you're now talking about now, or if you do in fact think the two are distinguishable.
We do not think the two are terribly distinguishable, and we argued in favor of retroactivity for Amendment 742. The underlying data about the lack of recidivism between people who received recency and status points was very similar. At the time, also, the data showed that there was racial disparities in who was affected. The problem is that there wasn't a hearing at the time on that amendment, and so those issues weren't really brought to the forefront. We know better now, and we've also been through more retroactivity cycles. Not to mention, in 2011, we were just coming off of the 2010 Fair Sentencing Act, and Amendment 750 was made retroactive, which was a huge project. And in the context of making that project retroactive, I think the recency points maybe didn't get as much attention as they could have. But we do think that that was the right call to make that amendment apply prospectively, and we wish it had applied retrospectively, but we can do better now, and we've got a lot more experience in doing that.
Vice Chair Murray, and then Vice Chair Restrepo.
I wonder if Mr. Nash would answer the same question that Commissioner Wong had, because my recollection is that your written submission does try to draw a distinction between recency and status points in terms of effect on fairness.
Well, I agree to a large extent that some of the underlying fairness concerns are the same. One distinction, and I thought she did a nice job of distinguishing why now we're giving more attention to those fairness concerns than was able to be given before, when there was no hearing and there were so many other things on the Commission's plate. I would also point out that in the comments of the Commission where the recency amendments were deemed to be not retroactive. There was some concern about the small number of people that would be affected by it. There was a number of about 8,000 thrown out, but there was discussion that there might even be far less than 8,000 that could even be affected. So it fell into that range of maybe this only has a minimal impact. Our amendments here clearly are not that. They're much more substantive and affect so many more people. So that would be an additional distinction that I would draw.
My question is directed to Ms. Mirchandani and Mr. Nash. Much has been said and written, and more will be said with respect to the burden these retroactive application, these amendments would have on the system. I'm curious to, and it's probably just anecdotal experience or testimony you could provide with respect to how districts that don't have public defenders and how districts with public defenders coordinated their CJA attorneys, and what kind of burden they should expect, and how would those districts and the CJA folks deal with this?
I can speak first to how the federal defenders dealt with it. And it was, a little bit scrambled with Amendment 706 because it was the first time we had done it. It got better and more efficient with Amendment 750. And by the time 782 came around, we were extremely efficient. We would work with probation, the courts, and the U.S. attorneys. It would usually be a one-page memo that was produced. Everybody would give their opinion. It was all done on paper. There was not a single hearing. In almost 600 cases, there was not a single hearing. Factual findings were occasionally made about drug amount or weight because there would sometimes be questions. That was this very small minority of cases. But it went very smoothly. And we didn't use we didn't refer a lot of cases to CJA counsel because there weren't a lot of conflicts that came up. But I cannot speak to where there isn't a defender office. I can only speak to where there was one.
How did the CJA folks in your district handle it in a similar fashion?
The federal defender took on basically all of the cases. Unless there was a serious conflict, then we would get CJA counsel appointed. But this actually reminds me of something that the previous witness said, Mr. Ritz. He said that the federal defenders didn't review all the cases for ineligible filers, and that's not true at all. In Maryland at least, there's a notice, so every single time a motion is filed, pro se, it would come to our office, and we reviewed every single one of those cases. So, and if we did not supplement the motion to the court, that our silence was basically the message that we didn't think the person qualified for relief, so we didn't supplement it. The government, I think, takes our silence as the fact that we didn't review it, but we did. We reviewed every single case.
And I take it, if there were factual disputes, people leaned on the pre-sentence reports?
Yes, pre-sentence reports. Basically, you couldn't make any additional factual findings, but the pre-sentence report basically told us enough.
Mr. Nash?
Right. So in our district, we don't have a full-time defender. We just have a CJA panel. And in past amendment cycles, all of our panel attorneys stood ready to assist in any way. If we were to be reappointed, we were ready to do that. A lot of us fielded calls from our former clients, even though we weren't officially appointed. We would field calls and consult with them and go through the same sort of process about advising them whether they might be eligible or not. I'm not aware that at any point in time in our district were there ever additional staff required in the U.S. Attorney's Office or the probation office or the judge's clerk's office. I think all of our retroactive amendments were handled without the necessity of that. And again, the CJA panel stood ready to assist just whenever we were needed.
Thank you.
All right.
Commissioner Bohm, and then Wroblewski.
All right. Good morning, and thanks to each of you for your very helpful and thorough submissions. I had written down a couple of questions and forgot my glasses, but I think that I can make it here, so bear with me. This is for Ms. Mirchandani, and then perhaps if Mr. Nash also wants to weigh in. Your letter advances that retroactive application will not be a significant burden on the system. But as far as I can tell, every other relevant stakeholder who has weighed in on this issue opposes retroactivity. The CLC committee opposes retroactivity. Every individual judge who provided public comment opposes retroactivity. The United States Probation Office did not take a position, but then went on to outline the, dozens of instances of significant burdens that will burden the system. Of course, we have the DOJ position, the AUSA position, and then, the Bureau of Prisons, I guess, through the Department of Justice. So, I don't think it's a matter of judges simply being too busy to right a past wrong, I think, as your letter phrases it, but rather every other relevant stakeholder opposes retroactivity, at least as far as I can tell. Now, again, there's the caveat with the U.S. Probation Office. So what do you say in light of that, I guess, that the burden is not significant?
Well, first of all, I think a lot of those letters, from what I noticed, were sort of assuming data that is not correct. One of the assumptions that we heard Mr. Ritz talk about is that this is going to be a public safety problem and that people are going to recidivate. What the data shows is that they actually are not more likely to recidivate, and we know that from prior cycles. Another assumption that sort of fueled a lot of the opposition is that 85,000 people will file. That's also not borne out by the data. The number of people who in the past who filed motions who were ineligible, it actually went down with each cycle. I think communicating with people who are incarcerated and letting them know what the criteria are will help reduce that more. And it will be a burden. It'll be work. I don't want to call it a burden, because even Mr. Ritz said he was proud of the work he did on Amendment 782. He was proud because it was good work and it was the right thing to do. And I think we're looking at the people who will have to work a little harder over the next couple of years. But the flip side is that if we don't make the amendment retroactive, the BOP has to bear the burden of incarcerating people 14 or 15 months longer than they need to be incarcerated. The burden is going to be paid one way or the other, either by the BOP or by the justice system. The difference is that either my clients are going to sit in a jail cell for that additional time or have a second chance at getting their freedom back. So in my opinion, it's worth the effort on our side. And it makes it easier for the BOP. They're also suffering from overcrowding. We know that from the most recent 2023 BOP report.
May I, Your Honor?
Please.
Okay. I echo all that. The easy work, there's work. The easy work is dealing with the motions that are clearly ineligible, where the clients are clearly ineligible, or they're pro se motions. That's the easy work. It's work, but it's easier. The harder work is dealing with the cases where the people are eligible and sorting through the records and coming up with the correct sentence at the end of the day. That's the 18 to 19,000 number. For Part A, there's only 12 districts that have over 200 of those cases. For Part B, there's only 6 districts that have over 200 cases. All the rest of the districts have 200 or less, and some of them, a lot of them, far less than 200 cases. So those are the ones that are going to take work, but it's not an unmanageable amount. And we already have the mechanisms in place. We've been down this road before. We've had retroactive amendments, several of them, and we know how to do it. We know how to triage these cases. The U.S. Attorney's Office knows how to do it. Defense attorneys know how to do it. We can handle it.
Just a quick follow-up. You mentioned that perhaps the Commission's retroactivity in 2010 and 2011 was informed by a recent retroactive amendment that perhaps informed the recency decision. In the landscape that we have today, assuming that the amendments on compassionate release actually, pass and take effect in November, then that would also expand grounds for compassionate release, and I would suggest that we'll probably see more of those motions as well. Is that a consideration that the Commission should take into consideration into deciding this retroactivity issue as far as additional burden? Because it won't just be retroactivity on this issue, but rather one would expect with the expansion of compassionate release that there will be additional motions for compassionate release. So should that play a factor or not?
I mean, everything is a factor. But I do not see compassionate release motions being standing in the way of retroactivity here. I mean, frankly, in Maryland at least, the big influx of compassionate release motions were filed during the pandemic. That was when we saw a wave of motions come in, and those have really stopped. We now are hardly seeing any compassionate release motions filed. So if there's more of a, some more motions filed in November, in my district, the criteria actually has narrowed compassionate release. It hasn't expanded it. I know that's different from other places, but it's also a very different situation. And it's not the kind of situation that can be done easily on the paper. This is a really more mechanical than compassionate release.
Thank you.
Commissioner Beluski?
Thank you very much, and thank you to all of you for being here and for your testimony. Ms. Merchandani, Mr. Nash, you know that the Justice Department has taken the position opposite from yours, and I just want to ask a couple of questions to try to tease out whether these differences are differences in the principles, the underlying principles of retroactivity and when they should apply, or whether it's about actually applying this particular circumstance to those principles. So in the commentary, Ms. Merchandani, in the commentary to Section 1B1.10, the Commission quotes the legislative history of Section 994U, and it says it should be, that says it should be noted that the Commission does not, the committee, this is the Senate committee that wrote the Sentencing Reform Act, that the committee does not expect the Commission will recommend adjusting existing sentences under this provision when there is only a minor downward adjustment in the guidelines. Your testimony suggests to me, and your written submission suggests to me, that you think this is wrong. Is that right? Or do you think this is correct? Policy, as a matter of policy, that if there's a minor adjustment, the Commission should not make that retroactive.
I think the policy is fine, but I think that what we're talking about is not in any way a minor adjustment. The Commission itself has called a minor adjustment 6 months. We're talking about well over twice as long. So I think we fit into the policy. I think the Commission's policy very much is in favor of retroactivity here.
Can I try to tease that out just a little bit? Because this, on the status point reduction, it's roughly the equivalent of a 1 offense level reduction. The most you can move is 1 criminal history category, which for most of the table equals a 1 level adjustment. Has the Commission ever, as far as you know, done anything less? Can it do anything less than a 1 level adjustment?
I mean, I don't know every single amendment that has been passed retroactively, but I have skimmed them. I don't think that the magnitude here is too small. 14 months reduction, even if it's, because we're talking about people where they are on the table, the 1 level reduction means 14 months. What's interesting is that that also is the same as 2 levels and a different part of the table. So it depends where you are on the table. 1 level can be a huge difference. 1 level could be a small difference. What we know is that the average is 14 months for Part A. Part B, a little bit longer. And actually for Part B, the 18% difference is exactly what was at stake with Amendment 782 with drugs -2. And the government didn't call that minor, but they're calling this minor. I'm not sure exactly why.
Got it. Can I ask another question about the process? So you describe in your testimony a very efficient process for considering 3582C motions. And you specifically say that you suggest that the 3582C proceedings are limited to the record as it existed at sentencing. This is from your written submission. As with every prior retroactive amendment, the availability of relief will depend on the record as it existed at the time of sentencing. That suggests to me that the record is frozen, that there won't be any new fact-finding. Am I reading that incorrectly? Is that what you mean?
The record is frozen about the offense. The record's not frozen about post-sentencing conduct. But if there weren't hearings, in the past at least, there were never hearings to say, well, did this person have a gun or did this other person have a gun? Whatever existed in the record was the basis for making decisions. And I should add, that's just about eligibility. So all of the concerns that were raised about, well, what about this person being eligible? That's just getting your foot in the door. After eligibility, there's still a 3553A analysis in every single case. So if there even if a person didn't personally have a gun and there were guns involved, the government could argue against relief. And in 40% of the drug cases, relief was denied. So this is that's just an eligibility question. And yes, it is based on the record as it existed.
So again, can I sort of probe a little bit, just a little bit more
Yes.
on that? So I think what you're suggesting is that the 3553A part of the analysis, there may be additional fact-finding. Am I correct on that?
I wouldn't call it, if you want to call it fact-finding, looking at the evidence, yes, looking at what has happened.
But at the first part of it, if the commission were to apply Part B retroactively, there are these new exclusionary criteria which there may not have been factual findings about them. So for example, there may have been a finding that the offense involved a victim who was financially ruined, but there may not have been a finding that the defendant personally was involved in that. That would require fact-finding, and I assume, am I correct, that there would be fact-finding about that part of the offense, or do you think that's wrong? And if I'm wrong, tell me why I'm wrong.
I think there might be searching and fact-finding in a very, very small number of cases. I don't dispute that we're going to have to figure out what those exclusions mean, but we're going to have to figure out what those exclusions mean even for prospective clients. And that is not a reason to deny retroactivity to everyone, because it will be a very small number of people.
How do you know it's going to be a very small number of people?
Because I've looked at the criteria and I've read a million pre-sentence reports, and generally a lot of the data that is talked about in the exclusionary criteria show up. If somebody has a gun, it is going to show up in the pre-sentence report. That is not something that's left out. The description of the offense and what the person's personal culpability was is going to tell us whether those exclusionary criteria apply.
Mr. Nash, can I ask you one question? And that is, your testimony suggests that that every sentence imposed under our current system, the post-Booker system, is sort of empirically very precise. And you talk about, and Ms. Merchandani talks about, that if we don't correct it, we're not correcting a systemic and fundamental unfairness. And you say when we have something that's wrong, and you describe it as wrong, that we need to fix it. But as you know, the criminal history score is a point system, and not every point adds to somebody's sentence. So someone with 4 criminal history points and someone with 6 criminal history points will be in the same category and will have the same guideline range, despite the fact that the Commission's research shows that they carry different risks of recidivism. So I'm just curious, am I capturing the system correctly? And do you think that people who have, the 2 people, one with 4 and one with 6 criminal history points, who were sentenced the same, do you think that is a fundamental unfairness?
Well, the data that the Commission has put forth has shown that the difference between 0-point offenders and everybody else is way more significant than the difference between a 4-point offender and a 6-point offender. There are differences between a 4-point and a 6-point offender, but it's not nearly as great as the difference between a 0-point and everyone else, which is what the Commission decided to fix. The Commission did not decide to fix, and it wasn't before the Commission, I assume, the differences in the other categories. So is there some argument to be made there in some other hypothetical case? Yes, there is. But what we're talking about here is the difference between the 0-point and everybody else. And that difference is so significant that I think we can fairly say that the sentences that 0-point offenders received were too lengthy in many cases. And because they were too lengthy, they deserve to be corrected.
So you're talking about, of course, Part B.
Part
But what
B.
about Part A, where the status points is two points, and it could be the difference between a 4 and a 6, or between a 5 and a 7, and that kind of thing. Do you think that that's a different analysis that the Commission needs to make?
Well, it is, because in the situation where it doesn't affect the person's criminal history category, they stay in the same category even though they're either at the bottom or
Is
the
that
top
a
of it.
fundamental unfairness?
Well, again, that's an issue that could be debated, but that's not what this Commission decided to remedy. The Commission only remedied the situation where it was so different that it knocked them down to a criminal history category. And so that, we believe, again, is enough difference in the initial sentencing to merit correction. Can we go back at some future date and talk about what you're talking about? Sure. But for now, we're only talking about where the criminal history categories have changed.
Thank you.
Mr. Wasserman?
Vice Chair Mate, and then Commissioner One, please.
Mine's really quick. I just had one clarification question on the process for you, Ms. Merchandani. With, you talked about how it's worked in the past, this collaborative process. Would you expect if the commission made these amendments retroactive, a similar process going forward?
Yes, I mean, we already have the relationships, the same people who worked on the 782 are still there, and I imagine that it would go even smoother, really, than the past, because we've gotten a little better each time.
Yes.
Do you have a sense of sort of geographic diversity or diversity between offices? I noticed it sounded like in your office, you were able to triage to the point where something like 95% of motions were granted. But I know that the national average is something more like 62% for that same amendment. And so it sounds to me like not every office is operating the way your office is. Do you have a sense of the geographic
I don't know
diversity?
how it works in other districts, but we're happy to share our formula if it would help the other districts be more efficient.
I had two questions for Mr. Wasserman. Mr. Wasserman, could you respond? Mr. Nash mentioned that U.S. attorneys' offices have the ability to triage, and we heard from the prior panelist that usually requires some kind of diversion of AUSA resources from other work. Can you just talk about on the ground in a tangible way what that triage looks like or what the trade-offs are? That's my first.
Make sure your mic is on, Ms. Wasserman.
My personal experience with this occurred with the pandemic. And my office, DC, is structured a little bit differently. It's the largest office in the country and has a section that's dedicated purely to local DC crimes. And then the smaller part of the office is the criminal division on the federal side. We have the good fortune of having a special proceedings division that typically handles all post-sentencing matters. With the pandemic, and I believe with some of the other amendments that have occurred over the years, those motions have overwhelmed that unit, which is still relatively small, their ability to handle the volume of motions. So, and I'm not in that unit. So I myself handled seven compassionate release motions in 2020 between, I want to say, about May to December. And that was, I think, consistent with what a lot of other people were doing. And the one saving grace in that situation is during that period, the court was mostly closed. So I didn't have, a court calendar, and some of the investigations that we were working on were delayed, but it was still a significant burden. And the reality of it is that the time that AUSAs, and I would say that most offices, in my experience, don't have a special unit dedicated to dealing with post-sentencing issues. So that's going to fall on the AUSA that handled the matter, or an AUSA that just happens to be there if the person's left. That's going to divert their attention away from existing investigations, current cases, and I think it's also important to note that with the expansion of the criteria for compassionate release, it would seem that we are likely to face a significant increase in compassionate release motions, which will also have to be handled by the U.S. Attorney's offices. So it's going to be the retroactive application that we're talking about here, and the hundreds or thousands, quite frankly, that are going to come in. And I think the thousands of compassionate release motions that we're going to get, after those provisions take effect. So that's going to, I believe, quickly overwhelm many U.S. attorneys' offices' ability to handle this and to conduct, their sort of ordinary casework. I would note also that as I understand it, the current budgets proposed in the House and the Senate include significant cuts to U.S. attorneys' offices. So I don't anticipate that there's going to be help on the way for U.S. attorneys' offices in personnel to handle this increase in the workload. So I do have significant concerns about the volume of work.
Time?
Yes, yes.
So my second question is, one thing that I didn't see really in the commentary was the fact that the vast majority of criminal cases are resolved by pleas. And I was wondering if you could speak to what extent the plea offers extended are kind of extended in the shadow of mutually agreed understandings of what the guidelines at the time are. So is there an argument, that the government would not have agreed to dismiss certain charges or cap allocution had the guidelines been different? Should that be a concern of ours at this point?
Yeah, I mean, in plea agreements, many plea agreements, which most cases are ultimately resolved through pleas, we do engage in negotiation with defense counsel about the guidelines, enhancements or bumps that can either be negotiated in or negotiated out. And those are things that are part and parcel of a lot of pleas. So if you now retroactively change the guideline range in a way that it was not contemplated by the plea, which had, what we know now been known then, might have resulted in a different disposition, you're impacting, essentially the heart of the plea deal. And I think that kind of goes to the finality of sentencing, the predictability of sentencing, that I think is important to the system and people's confidence in the system.
Yeah, yes. Yeah, no, go ahead.
This is a question for any of the three of you who are interested in answering. One argument I saw in the materials from several of our commenters, so our tribal issues advisory group, several of the probation offices that commented, is that this is the first sort of cohort of potential offenders who are really, by and large, sentenced post-Booker, who we'd be looking at adjusting sentences of retroactively. And in particular, that the first commission study on on recidivism rates and how status points affect them came out in 2005. So the data has been there for a little while, and judges have had freedom for a little while to consider it. And I'm wondering, just empirically on the ground, how much did you see those arguments being made by advocates? Like, did you as defense attorneys, or you as someone who was opposing defense attorneys, hear people making arguments about, look, status points don't really impact recidivism. This criminal history overstates the seriousness of this person's background. Did you see judges taking it seriously? Did you see the government, how was the government reacting? I'd be interested in hearing what three of you saw on the ground.
I mean, from my experience, I've not seen defense counsel argue that, and there may be a number of reasons. One is just wasn't something that was on that particular person's radar screen, but I think it also demonstrates that status points exist for reasons beyond recidivism risk, and I think the Criminal Law Committee from the Judicial Conference pointed that out, that there are other factors, and I think the commentary to Chapter 4 makes that clear, that this is also about, culpability and, essentially the escalating set of consequences that is imposed on repeat offenders throughout the sentencing guidelines. So I've not seen that argument. Perhaps maybe we'll start to see it, if this amendment passes retroactively or as the amendments even start to kick in November.
I'm not sure exactly how much this argument was made, but what we do know is that more than 62% in the Part A and more than 50% in the Part B category, people received within guideline ranges. So yes, there were some cases where there was departures or variances, and we don't know what the reasons were. But for the most part, courts accepted what the commission presented as the appropriate amount of time that would be sufficient but not greater than necessary to serve the purposes of sentencing, and they trusted that. And we know that courts look at the guideline range, but they don't necessarily think about every single different factor that went into creating the guideline range. So to the extent there are courts that routinely departed downward because of this, they don't have to give relief. Again, this is just the ability to give relief.
And did you have a sense of whether the argument was being made on the ground?
I don't recall it being made.
My experience is the same. I think this would have been a very rare argument that would have been made at the time of sentencing.
Thanks.
I think I'll have the final questions. Mr. Wasserman, you indicate in your testimony the rule of law relies on finality and predictability. What I've been hearing from Mr. Nash and Ms. Merchandani, they've been focusing on fairness about the rule of law. Should fairness also play in an analysis of what the rule of law ought to be?
Yes. I mean, of course, fairness should factor into it.
Okay.
Tell how often I do this kind of thing. Yes, fairness certainly factors into it. It's a core part of sentencing. I don't think, and again, to sort of cite to the Criminal Law Committee, the Judicial Conference, I don't think fairness is as significantly implicated with these amendments as perhaps some of the other amendments, the crack powder disparity, the drugs -2, in this particular instance. Ultimately, though, with respect to finality and sentencing, I mean, parole was eliminated for a reason, because it severely undermined, the reality of what somebody's sentence was at the time that they were sentenced. And there was always this idea that you were probably going to get out earlier than what your actual sentence was, and it just undermined public confidence in the system. I think that's a significant part of what the commission should be considering. Can we have confidence that the people, that offenders are going to serve the sentences that are imposed on them, or are we always going to go back and lower those sentences for, any number of reasons, or offer, opportunities to get sentencing reductions? And I'm not saying that, we shouldn't be revisiting and refining how we do sentencing, but I think, we need to be circumspect about how we do that. And I think we need to really focus, in significant part on the fact that, ultimately for all the recidivism studies, the recidivism rate in the federal system is still about 50%. So there's a serious public safety aspect to this about releasing offenders into the community early. So, those are, I think, concerns that need to be considered.
The other question that I had, and this is for the full panel, because what I think it's in your report, Mr. Wasserman, one of the arguments you make is on the zero criminal history might create more disparity because white collar persons are more likely to be white defendants and all that, and you say that increases disparity. What I heard Ms. Merchandani and Mr. Nash talk about was the increased disparity on the sort of the more violent criminals or criminals who did not fit into that category. How should the commission balance that, if at all? I mean, because you say, well, it's going to increase the disparity in one class or group of people. You, Ms. Merchandani, says it increases disparity in another group.
Yeah, I think that, racial disparity in sentencing obviously has a lot of different causes and factors, many of which exist sort of outside the criminal justice system. So on the 2-point offender or the status point offender side, I don't think racial disparity is the appropriate means to address racial disparity in sentencing. It's not going to resolve the problem because, again, there are a lot of reasons why there are racial disparities, and this I don't think deals with the core problem. I think there's also assumptions that the primary cause or mover of racial disparities is on bias, and I don't necessarily think that the studies bear that out. But to the extent that there are racial disparities which are undeniable, and that there is data that shows that some of those disparities cannot be explained by objective factors, and I think the department's 2012 study, bore some of that out. We shouldn't be exacerbating those in the 0-point offender status guideline, which would seem to do so by benefiting disproportionately white-collar offenders who are more likely to be white. So that's the distinction.
Ms. Burch, you may answer Mr. Nash as well.
Okay, thank you. First of all, the white-collar defendants are a pretty small proportion of the people. I'm not sure why that became a sudden focus for the DOJ and for Mr. Wasserman, but more than 75% of people that we're talking about in Part B are drug offenders, and most of them we know are people of color. And I'm not sure what it's like in DC, but in Maryland we have a lot of white-collar criminals who are people of color. It's not exclusively white people who commit white-collar offenses. So helping everybody is the right thing to do. Not even helping, it's not leniency. Giving people the correct sentence is the right thing to do.
Mr. Nash.
And I would echo that. The statistics in the impact report are that the people who will benefit potentially under Part B, 69.9% Hispanic, only 16.9% white. So I'm not sure that there would be a disproportionate, sort of an inverse impact on the Part B component benefiting white offenders more than people of color.
Thank you. Thank you all panelists. I know we ran over, but thank you so much for your time and consideration of us. We will now take our morning break, and we're going to take the appropriate amount of time, 15, 20 minutes to get back for everybody to take a break. Thank you so much. Thank you all for your patience. I think we needed a well-deserved break that probably lasted a little bit longer than I anticipated, longer than I announced. I anticipated it would last a little while. Our third group of panelists will provide us with perspectives on this issue from 3 of our advisory groups. First, we will hear from the Honorable Ralph Erickson, who serves as chair of the Sentencing Commission's Tribal Issues Advisory Group. Judge Erickson served as a district judge for the District of North Dakota before being elevated to the United States Court of Appeals for the Eighth Circuit. Judge Erickson has a long history of service on state and local courts in North Dakota, as well as state and national ethics panels, including service as chair of the Judicial Conference Committee on Codes of Conduct. Second, we will hear from Francie Hakes, who serves on the Commission's Victims Advisory Group. Ms. Hakes was a prosecutor for 16 years at both the state and federal level. She was also appointed by the United States Attorney General as the country's first national coordinator for child exploitation, prevention, and interdiction, where she created the inaugural U.S. strategy to address child sexual exploitation. She is now the CEO of her own consulting firm, where she provides advice regarding the protection of children. Finally, we will hear from Joshua Luria, who serves as vice chair of the Sentencing Commission's Probation's Officers Advisory Group, POAG as we call it. Mr. Luria serves as a supervisory U.S. probation officer in the Middle District of Florida. He has previously served as a U.S. probation officer in Brooklyn, New York. Judge Erickson, we're ready to hear from you, sir.
Thank you, Chair Reeves, members of the commission. I want to just thank you for the opportunity to be here this morning, first of all, on behalf of the Tribal Issues Advisory Group. I want to start basically by laying out a little bit about the Tribal Issues Advisory Group itself, because it's a little different than the other advisory groups in the sense that we have membership that represents the entire spectrum of interest in the sentencing process. We have a U.S. Attorney representative, we have a federal public defender representative, we have practitioner representatives, we have tribal court representative, we have a probation officer representative. And so like the commission itself, we represent a diverse set of views. I also would like to explain that we've talked about having a substantial majority believing that both Subpart A and Subpart B should be retroactively applied. And we have a minority, which we describe as a small minority, that disagrees with that position. When we talk about a small minority, we're talking about a minority of 1 or 2 members, right? And so that's where our advisory group is sort of on the recommendations that we have here today. The second thing I'd like to talk about briefly about Indian country is this. You know, the point of view that we bring to the table really is what happens to Indians who are convicted of federal crimes in Indian country. And being an Indian under federal law is different than being a Native American, right? Because being an Indian is a status. It means that you're enrolled as a member of a tribe and that you are engaged in some conduct in Indian country that exposes you to prosecution in the federal courts. And by definition, most of what we're talking about here in the federal courts with Indians being sentenced in the federal courts is as a result of tribes that are non-public law 280 tribes. And that is, these are cases in which the federal courts are primarily responsible for handling the prosecution of felonies in the federal system. And the great bulk of these crimes fall into either the Major Crimes Act or the Assimilative Crimes Act. And when we look at what that means is that we are applying state law crimes, we are prosecuting people for state law crimes in federal court. So the elements of the offense are established under state law, and that's what we're prosecuting. and it's ordinary street crime. I mean, it is rape, murder, vehicular homicides, felony DUIs, just the entire broad gamut of felonies that exist in the state courts, but we're trying them in federal courts. And of course, under the federal sentencing law, the federal law of sentencing applies to those cases, right? And so there's a couple of things that happen when you look at the Tribal Issues Advisory Group. When we look at sentences in federal court, we're really looking at state crimes that are being prosecuted in federal court and federal sentences are being imposed. Now, if you think about what this means in a practical matter, it's like if a person is a non-Indian who commits exactly the same crime in exactly the same place, and very rarely, but occasionally, in concert with an Indian person, they will be prosecuted in state court, and the state law of sentencing will apply. If they're an Indian and the crime is in Indian country, they will be prosecuted in the federal courts, and the federal law of sentencing will apply. In most circumstances, the sentences imposed in the state courts are significantly less than the sentences that are imposed in the federal courts, all right? And so when we talk about all this group of people, the tribal judges, the tribal prosecutors, the tribal commission members, they're looking at this and they come to this with a point of view that the sentencing law as applied to Native Americans is often unfair. Now, I would be wrong or I'd be amiss if I said this was universally true, because there are a state or two that impose longer sentences than the federal courts do, and that is also a factor in this system, right? And so when we talk about Part sub A and B and retroactivity, we come to the table with a substantial majority just with the idea that the federal sentencing rules already provide for unduly harsh and long sentences in comparison to the average person who's committed a similar crime who is not an Indian, all right? Now, as a result, it's also true that we come from primarily more rural areas, and we have generally smaller numbers of defendants generally, and that means smaller numbers of people being sentenced. And so on some of the issues as we look at it, that our experiences are different than, say, in the previous panel, the person who was in the DC district, right? I mean, because it's just a different thing. Although in the DC district, they've got assimilative crimes jurisdiction over the George W. Or the George Washington Parkway as well, which is interesting, but neither here nor there. In any event, when we put this all together, we think that if you apply the criterion that the commission has already established, that, and I'm not going to go through point by point because I already did that in my letter, and I've already gone on longer than I should, and I figure you'll ask me questions if you think you have to. And so what I am going to say is we think as you apply the categories and you look at them, that basically the question of justice for the people we are concerned with, both the Native Americans who are sentenced and the Native Americans who are victims. But we believe that as a matter of justice, that retroactivity is appropriate as to our defendants. When you look at the burden on the courts, we do not believe that the burden is such that it outweighs the interest of justice in this case. And we think that if we're looking at a relatively small group of people who will be actually eligible, there will be a significant number of filings made. I mean, that's just in the nature of what happens anytime we apply the retroactivity to a guideline amendment. But the reality of it is most of them will be ineligible. Most of them will be relatively easily identified on the papers and will be decided relatively quickly. I mean, if you just look at what we've done with Drugs -2, the other retroactive applications, the people who don't qualify are pretty easily identified and pretty easily moved out, right? And so I I don't, and I understand that all of my district judge friends have all written letters and said that this is just a huge burden. That was not my experience with drugs minus two. You know, if you look at it, you know, I've been a federal trial judge from 2003 to the time that I took the bench in the circuit for 2017. We went through a number of retroactive applications. What we really found was this. The first time we had to invent the wheel, it was ugly and difficult. The second time, slight modifications were made and we were able to apply it. And by the third time around, it really functioned pretty smoothly, right? I mean, that every time we've had to do it, we've been able to put together a system that functions with a little less initial input and effort, right? And I think that really, when we talk about compassionate release and the COVID thing, it's a unicorn. It was a large number of cases. It took a large amount of time to try and figure out where we're at when nobody was in the building and everything was messed up and everything was difficult. And I think that we're better off looking at the other amendments to the guidelines directly that kind of happened while the courts were doing ordinary business. And I think that to some extent, the burden that the judges are complaining about is slightly overstated. I mean, I think that they'll get it done, right? And I think that really effectively kind of, without going through the detailed analysis, summarizes what I'd like to start with, and I'd be happy to answer any questions to the extent of my ability to do so.
Thank you, Judge Erickson. Ms. Hakes.
Thank you to the members of the commission. My name is Francie Hakes. I'm a member of the Victims Advisory Group for this commission. I'm also a former state and federal prosecutor. I was this country's first national coordinator for child exploitation prevention and interdiction. Eric Holder appointed me to that position in 2010, and when he offered me the position in something I will never forget, I'm quoting him directly here. He said, "I'm going to ask you, no, I'm going to demand that you be bold and aggressive in this position." He didn't really know it at the time, but bold and aggressive pretty much defines me and my career, during which I've advocated for victims of crime. I specialized in crimes against women and children, so I've advocated for a lot of victims. So when I argue here, as I do, against the proposed retroactivity of the criminal history amendments, I do so with a wealth of cases and victims that inform my opinion. I have sat in my office and in their homes holding the hands of children as they relive the horror that they endured at the hands of a sex offender. I've held the hand of a woman terrified to go home because she's being stalked and will never feel safe unless the offender is imprisoned. More times than I can count, I nonetheless remember every single face. Only a robot would be unmoved by their fear and their tears. I also remember their astonishing bravery in standing up against their offender in court, both in trial and at sentencing. My promise to them was always that they would make a difference, and it bolstered them as they testified. I never promised convictions, but I always promised that I would fight for them and fight for justice. As I went from state to federal court, I was able to make an additional promise: truth in sentencing, because that is the system under which I practiced as an AUSA. Prosecutors and victims advocates across this country have made those same promises to countless victims, and district judges have explained carefully to victims and to offenders that the sentence imposed in court means something, that they could be certain of the offender's incarceration for the period of time imposed by the judge. Now, the commission proposes to open the floodgates, as the Department of Justice has also argued, to tens, potentially tens of thousands of offenders who will petition to have their sentences adjusted downward. This will result in many offenders being released before the sentence runs that was imposed by the district court. The push to open the doors of the jail is shocking enough, but more shocking still to me is the utter lack of any mention in any relevant way of victims or victims' rights in the impact analysis that was done for the commission. It appears to me that once again, victims are not the focus. The focus is those who literally prey on others instead of on those who are wholly innocent as they traverse the criminal justice system. My question is why? Why are victims being ignored in the push to release offenders who have committed crimes like firearms offenses, murder, kidnapping, manslaughter, stalking, child pornography, and sexual abuse? And I will reiterate something I argued in court thousands of times. Child pornography is not a victimless crime. I don't think the general public has any idea that these crimes with real victims and which involve serious sufferings at the hands of these offenders are part of the push to open the jails. I can only assume that the answer to why victims are being disregarded is because, unlike me, unlike the nation's prosecutors and victim advocates, the policymakers behind the decision have not had to sit in front of victims of crime and promise to seek justice for them. They haven't taken calls on weekends and at night, in the middle of the night, from victims fearful of what will happen to them in court or what might happen if the offender gets out. They've not had to look into the eyes of a child depicted in horrific images of child abuse and who can barely breathe knowing that others have
is now joining.
I apologize for that.
Okay.
Yeah.
Knowing that other people besides the offender have seen these horrific images of the worst moments of their lives. I can assume that the policy members have not seen the terrible, should I wait?
Yes. We're, right. Judge Gleason, please mute your microphone.
I could only assume these policymakers have not seen firsthand the fear of someone being stalked or who's been kidnapped. They must surely not have seen the terrible wounds resulting from gun violence or spoken directly to those trying to live in neighborhoods ravaged by drug trafficking. These people who will be released, make no mistake, who will be released are actual predators. Webster's definition of predator is one who injures or exploits others for personal gain or profit. The crimes in this proposal perfectly illustrate that definition. And we certainly appreciate at the Victims Advisory Group these public hearings, but it seems as though the victims have already been forgotten by these amendments that effectively reinstate parole in a system victims have been told it didn't exist. This proposal violates victims' rights under the law, and I hope the Commission will remember that those preyed upon by these offenders are real people. They deserve protection. I'm here for them. I speak for them. I advocate for them, and I will do so boldly and aggressively. I believe this proposal is wrong. Thank you.
Thank you, Ms. Hakes. Mr. Luria.
Good morning.
Morning.
On behalf of the Probation Officer Advisory Group, thank you for the opportunity to provide testimony regarding the possibility of retroactively applying the amended guidelines on status points and the new section 4C 1.1. According to the background components of section 1B 1.10, among the factors the Commission should consider in selecting to make a new guideline retroactive are the purpose of the amendment, the magnitude of the change, and the difficulty of applying the amendment retroactively. It seems like the purpose of the change to status points was to remove an enhancement that, upon further study, added little to the overall predictive value associated with the criminal history score. As for the new 4C 1.1 guideline, it appears this amendment was intended to create a structured reduction when considering defendants with 0 criminal history points, formalizing what courts have historically considered at the time of sentencing. Neither of these changes, at its core, seems to address a newly discovered injustice, nor a recognition of an unjust sentencing practice. These factors tend to weigh against retroactivity. However, POAG believes it would be insensitive to ignore the magnitude of the change on individual lives. According to the Commission's study on the impact of retroactivity, each of these changes would, on average, reduce a defendant's incarceration by 14 or 15 months, respectively. Additionally, either one of these guidelines, made retroactive, would impact thousands of defendants. The purpose and the magnitude should be weighed in comparison to the difficulty in applying these changes retroactively. In our written testimony, POAG discusses at length several concerns related to the difficulty of applying these changes retroactively, which was the focus of most of our commentary. With regard to status points, the retroactive application appears fairly routine in its execution. However, prior challenges to the criminal history scoring may need to be addressed, as well as new challenges such as how this retroactive application may impact the guideline or statutory safety valve consideration and how safety valve could be applied. As for the new Section 4C 1.1 guideline, the retroactive application will be more complicated and will present the courts with having to apply a new guideline that has several qualification criteria and conduct additional fact-finding with potentially missing relevant facts, and do so as part of a limited resentencing. Section 4C 1.1 has criteria that differs linguistically from other fact-finding the courts have previously engaged in, which will result in additional hearings. There is a further complexity to retroactivity for both amendments. It is more easily seen in Section 4C 1.1, but it applies somewhat to status point retroactivity as well. That is this: the criteria at Section 4C 1.1 gives articulation to some thought processes that courts engage in when considering a variance for defendants that have no criminal history points. And those thought processes may not be sufficiently captured in the statement of reasons or sentencing transcripts. This same problem may exist in part with regard to status points. A judge could simply have indicated that the criminal history category was overrepresented without specifying why. In the post-Booker era of sentencing, judges have had a lot more discretion to impose a sentence they believe to be correct. Those sentences are often in consideration of many of the arguments being made in the formation of these guideline amendments. It would be a significant undertaking to address factors the courts already had discretion to consider. Further, while the structure doesn't require an assessment until requested, it has been my experience that as a matter of practice, each case that had the potential to be impacted would need to be assessed, regardless of whether they requested an assessment. Every case that had received status points would need an assessment. Every case that had 0 points of criminal history would need an assessment. Similar to Amendment 782, wherein every defendant sentenced with a reference to Section 2D 1.1 needed an assessment, a similar approach would be needed here. Though I believe the 782 retroactivity was easier than this would be. POAG observes that we are public servants and we have handled complex retroactive activity in the past. It will take effort, time, and court resources to address these changes if they are made retroactive. While the probation office will stand ready to assist if one or both of the sections are made retroactive, we would ask to have a delay in the implementation by at least 3 to 6 months. This would give us additional time to front-load filings in advance of implementation and minimize public safety implications so that our supervision officers can prepare for a temporary surge in immediate release cases. Again, thank you for the opportunity to share POAG's perspective on this important issue.
Thank you, Mr. Loria. Turning to my colleagues. Judge Restrepo.
Mr. Loria, I'm curious as to, could you walk me through how probation would use the 3 to 6 months from a boots on the ground perspective to get us some idea as to how that would help you if these amendments were made retroactive?
In previous efforts for any retroactivity, there's a substantial amount of collaboration that occurs at the onset with other stakeholders in the court. The U.S. Attorney's Office, the federal public defenders, the court, the commission, to try and get lists and understand what kind of response we're going to be looking at. Get a sense of what the protocols are going to be, what the expectations are. Once we have that, we can start also building out what kind of forms we're going to be using to make these more of a uniformed effort. those forms look differently if it's eligible versus ineligible. Person that we think to be eligible is going to have a lot more information necessary for the court to make determinations, including sensory information related to their post-conviction activities while in custody, educational efforts, disciplinary history, versus ineligible. There's a lot more indications of why somebody might not be eligible. But a lot of times that front-loading information to the court allows them to make rulings in advance, especially for individuals who are going to be immediate release. Getting a sense of what those numbers look like allows us to better prepare for that on the supervision side of things, in terms of possibly moving additional cases out to who are lower risk, so that those caseloads can be absorbed. The first 60 to 90 days of any new case, there's a lot of activity that goes on in supervision in terms of establishing plans, assessing risks, those kinds of activities. And doing those kinds of things allow supervision to not be overwhelmed by that temporary surge of activity. Mostly giving us that additional information so that we can allocate resources better.
Mr. Robluski?
Can you describe, Mr. Luria, just how far in advance the release and reentry planning process begins? It was described earlier. I'm just curious your experience in that and what that actually entails.
Yeah, my experience is somewhat more limited because I'm on the pre-sentence side of things. I don't deal with post conviction as often. What we do see often is we see that side of it through these retroactive efforts. While I heard earlier as well that the BOP has made an effort to get those plannings pushed from a 6-month window to an 18-month window, a lot can change in 18 months when it comes to release timeframes and release planning as well. Part of the reason why it was initially a 6-month window is just because of how much shifting can happen last minute. But I don't think that has been as much an implementation, as much of a problem in it, in terms of making those plans work. You know, we have supervision officers who are willing to go out and do those visits and get that information in advance, so courts know that when they're being released to a stable residence and so forth. I haven't seen anything that suggests that window's shifted substantially, but you know, every retroactive is different than the last.
Vice Chair Mate?
Thank you all very much for your testimony today. We really appreciate it. Mr. Luria, I'm hoping I can impose on you in your capacity as a probation officer in the Middle District of Florida, which I know, and ask about past practices there. So I know that with Drugs -2 and other prior retroactivity motions, there was a lot of activity in the Middle District of Florida.
Yes, ma'am.
And if you're familiar with the process, for example, with Drugs -2, whether you could kind of walk us through what that looked like in the Middle District of Florida?
I was not involved in the planning side of it, but I was certainly involved in a lot of the authorship of the memos and some of the post-initial meeting activities. There's a substantial collaborative effort. Meetings occur between the AFPDs, the U.S. Attorney's Office, and probation to try and collaborate in terms of our effort to generate lists together to establish some kind of basis to operate off of. From that, an omnibus order is put out. That omnibus order gives protocols and expectations that's easy for us to all operate under, allows us to share information, which is actually very important, especially when you're dealing with pre-sentence reports. The AFPDs represented all the cases in those circumstances by order of the court, and that made that information sharing a lot easier. We actually used, with our Middle Florida, we had slightly over 900 782s that were on the commission list. In speaking with the person who handled that the last time I had spoken with him about it, and this was many years ago, we had a list that was closer to 1,400 or something along those lines after, all was said and done, I guess. But we ended up doing days where we'd do retroactive days. We'd set aside a day or two per month to try and get together as a group and work through as many of them as we could. Same room, that way we could kind of troubleshoot problems as they arise and get as many filed, accurately as possible. If we had problems, we could contact, we had a contact at the AFPDs, we had a contact at the U.S. Attorney's Office, and we could kick around those more difficult problems as we try to kind of solve those issues in advance. A lot of where we could build consensus, we did. But there are other times where the more times that these guidelines connect to other parts, the harder it is to build consensus. And so drugs -2, 782 was very easy. It was very rote. You're just reducing. -2 across the board. There's not a lot to it. 4C 1.1, when you add a list of criteria here, it's going to create a lot more areas where consensus cannot be easily made. Status points, a little easier, I think. But there are certainly jurisdictions out there where the First Step Act changes to safety valve have been pulled into the guidelines through 5C 1.2. And because of that, the change to a status offense will actually impact how the court might have looked at the guidelines in that structuring. And that, in part, actually might have impacted decisions that were made by the defendant. If they have 4 criminal history points and they're already ruled out of safety valve eligibility, then maybe they chose not to proffer. And the fact that they chose not to proffer in a retroactive structure might remove them from consideration now for a safety valve, even though that decision was made at a time when certain things were viewed a certain way. And so there's a lot of moving parts to these, and it makes it a lot harder to have that consensus building. Harder, I should say, than the drugs -2 issue.
Thank you.
Mr. Wroblewski?
Thank you. Judge Erickson, thank you for being here. I've got a question for you. In your considerations within the advisory group, was there a discussion of the impact on victims of retroactivity? And I'm curious, especially because you described the docket that we're talking about and that the tribal advisory group is interested in, that is concerned with, as being street crime. You described it, murder, rape, robbery, the kinds of cases where there are victims, which is very different than drugs -2, which may or may not have victims. So I'm curious about that. And do you anticipate that victims would be contacted in each of these cases, that they would come to court and have an opportunity to say something in court? I'm just curious about these issues.
Yeah, when we spoke about victims, it was very briefly during the hearing, and it was limited to the idea that if there were crimes that had true victim impacts, that the judges are not likely to revisit those sentences in the same way in any event, right? And really, we're talking about a relatively small number of judges, and most of the people on in our advisory group have judges in mind, and that's kind of where it was at. And so we did not discuss whether the victims would be contacted, who would contact them, what would the process be. It really is like, if you look at it, the general view in Indian country is that the guidelines on sex offenses are not significant enough, right? And so that's unlikely to change in the 3553A analysis. That's also true if you look at the vehicular homicide sentences, which in in the federal guidelines you'd compare to involuntary manslaughter, and you look at those manslaughter cases, and they've got sentences that are much shorter than what you're seeing in the state courts. And I think that judges have taken that into consideration post Booker as well, and would continue to do so in the 3553 analysis. So I guess we did not spend a lot of time talking about the victims, other than just to say in those crimes in which there were victims that we would trust the judges to make the right call, which, if that makes sense.
Vice Chair Murray, hold on for 1 second. One of our panelists has interruption with flights, I think, or something. Have you been able to get one? Okay, all right. I'm willing to do whatever's necessary because we do want everybody to get the opportunity to be heard at least. Okay, all right. Vice Chair Murray, I'm sorry.
I have a question for Mr. Luria. In your capacity as someone who sees a lot of PSRs, what is your sense of how often fact-finding, and what kind of fact-finding, will it be an evidentiary hearing, will be necessary if we make Part B retroactive? Do you think this is a de minimis number of cases? Is it a substantial number of cases? How often will it require witnesses? I realize this is asking you to forecast, it's impressionistic, but what do you think that's going to look like on the ground?
It's very tricky. And I've heard previous testimony talking about the reliance on the PSR, and we do what we can to include information that we think is relevant, always. But retroactivity kind of always makes us feel myopic. When we get into that structure where, why did I phrase it that way, or why couldn't I have asked this question? And there's a lot in there. We get into it a little bit in our written testimony. The ones that kind of jump out, I think, are substantial financial hardship. That's a big one. And that's a very difficult one because it actually involves coming back and getting victims to discuss it. And it's the language is just barely not the same. Being directly responsible, that's a different finding, and it's not one that we anticipated in the way that we looked at this issue in terms of the PSR. So we haven't, we try not to lay blame unless we have to say this is definitely the defendant who did this, or definitely the defendant did that. If it says the offense included, we keep it to the offense included. Kind of a similar one is the credible threats of violence in connection with the offense, or not, sorry, death or serious bodily injury. So under 2D 1.1, you have that fentanyl with overdose kind of structuring. A lot of those that I've seen have very low criminal histories, oftentimes nothing. And so they will have taken fentanyl that they received and passed it on to somebody else. That person overdoses or dies, and they're the direct result of that. And they have avoided getting a sentencing enhancement because that's a different plea. And because of that enhancement isn't applied to them because it requires that they be convicted of that to get that enhancement. So this is an area that we wouldn't normally be looking at. You have all these cases where, in recent time, we've had many of these cases. It has gone from a situation where it would only be given to specialists to now everybody across the board has had them. So those types of cases that have 0 points, we would now have to have additional fact finding to go back and say, were you the direct cause, or did you cause serious bodily injury or death in your conduct? And it kind of connects in there. And there's a lot of these additional things like that.
And is your thought, sorry, this is a rookie question, but is your thought that going forward, probation officers will now start asking, anytime they have a defendant who has 0 criminal history points, will start asking those questions?
Oh, definitely.
For sure, yeah.
I mean, absolutely. Even now, as it looms, as soon as we see the new criteria, we start trying to find ways to include information in there, because even if it isn't relevant yet in terms of guideline consideration, it absolutely is in the minds of the defense attorneys, the judges who are looking at this as possible variances to confer that benefit in advance of it becoming active in November.
Just that this is also a rookie question, but to what extent is there nationwide uniformity among probation offices for some of these more tricky issues or interpretive issues that you mentioned? So For instance, in 4C 1.1, the defendant did not personally cause substantial financial hardship as an exclusion. Personally, substantial hardship, like all those terms, I can see, as you noted, sort of this collaborative effort to reach consensus within a jurisdiction. But is there nationwide guidance that ensures some uniformity across sort of what probation officers, how they would be interpreting that? Or could there be an additional layer of complexity where different districts start interpreting those exclusions differently?
This is in terms of previous fact-finding efforts, those sections. I think the adversarial process kind of creates that uniformity, because if I were to without necessity, say that a defendant was the proximate cause of the serious bodily injury or death of the defendant, I would expect that would be objected to. And that would probably, because it doesn't need to be considered, be removed from the PSR. And so looking at that, if we don't have to lay blame, then we won't. We'll just meet the criteria. If the criteria doesn't require that the defendant be the one who's responsible, there's no need to go beyond that. If you do go beyond that, oftentimes you're going into the adversarial structure where you're going to draw objections. You're going to have people arguing back, no, that's not okay. So while there's no national guidance that says, hey, don't ask if they directly cause substantial financial hardship, if they're the direct cause of it, the process itself kind of tailors the responses. If that makes sense.
Judge Boone?
I have a question for Ms. Hakes. Thanks to all of you for your submissions. We really appreciate it, and the time you've taken to come talk to us. I understand the Victims Advisory Group's position is against retroactivity, but if the commission were to make these amendments retroactive, what would your recommendations be for how to inform and involve victims as part of that resentencing process?
Thank you for the question, Judge. I wanted to say, in answer to your question and listening to the testimony earlier today, I've been in a lot of sentencing hearings. I've advocated in a lot of sentencings, and the PSR is always a source of conflict. It is never, ever, in my experience, just simply agreed to by the federal defender or the defense attorneys, ever, or even the judge potentially. So you've got a document that is viciously sometimes attacked inside the sentencing hearing. So for some of the people who on the panel earlier had said, oh, we're just going to do this retroactivity, we're just going to lower sentences on the paper, it is never going to work, because you have prosecutors and defense attorneys who don't agree about the contents of that at a sentencing hearing. How can they agree 3 years later or 5 years later, or if they're not even the same people, or you have a new judge? You're talking about potentially people who have no experience in the case. They've never talked to the victim. They don't know the offender. They weren't at the sentencing. They didn't hear from witnesses. They didn't hear from character witnesses. They have no context other than potentially the paper. And paper does not give context, and paper does not give voice to victims. And when you're talking about a process that is going to impose effectively a parole system now, when victims were told there was no parole in federal sentencing, truth in sentencing meant something, you absolutely have to include the victims. There has to be fact-finding. There's just simply no way to lower sentences, certainly in Part B, there's no way to lower sentences without going back to fact-finding. Because I think you're going to be hard-pressed to find federal defenders, in spite of what we heard earlier, who are going to look at the PSR and go, let's just accept all those facts. They fought tooth and nail against those facts at the sentencing hearing. So they're not going to just accept them now, especially if it's a new defense attorney who sees weaknesses in those PSRs. As Mr. Luria said, they are not tailored to the new guidelines changes that you are proposing here. And so we certainly oppose it. If it does go retroactive, then we would certainly say there simply must be a hearing. Because to say that you can lower these sentences based solely on paper is to completely misapprehend the nature of sentencing hearings altogether, because these sentencing hearings are hard fought and the guidelines are advisory. So you have judges post Booker who've already imposed these sentences based on what they believe is in the best interest of the case, based on their hearing from victims, looking at victims' letters and hearing victims' testimony, hearing from the defendant potentially, character witnesses of the defendant, all of these things the judge has already taken into account. And so I also wanted to say, I'm sorry, it's a little off topic, but I also wanted to say, I cannot believe how many people have said that the reason for these changes is some sort of fundamental unfairness in the prior sentencings. Most of you are judges. You all know these sentencings are mini trials. You've got advocates fighting hard for the government side, advocates fighting hard for the defendant side. And then you've got a judge who has to play referee and make a decision on sentences. So to say that this has been fundamentally unfair, I think is just completely wrong. But as the Victims Advisory Group, what we would say is there simply must be hearings, and victims deserve and by law have the right to be heard at a resentencing. And arguing that this is not a resentencing is just semantics. It's just playing games with words, because it is a resentencing. When you are going to look at facts, when you have to look at things about whether or not someone is personally responsible for causing this financial harm, or whether there was a threat of violence, these are facts that can only be given by the victim of the crime. And so they deserve to be heard in this. They deserve to be notified. They're going to have to be notified by victim witness at U.S. attorneys' offices who are already overburdened, underpaid, and understaffed in trying to make the communication that they're required to make when there is every single kind of hearing. They have to contact victims, but they're going to have to take on that burden and contact the victims, who will have a right to come into court. And I just want to remind the panel, the commission, that when every single time these victims are contacted, every time they have to think about the crime, every time they have to talk about the crime, is another re-victimization of them. But they deserve the right to be notified and the right to be heard. So we would ask for hearings. Thank you.
Judge Erickson, I do have a question, just one question of you. A district judge to a court of appeals judge. Can't pass the opportunity to ask you a question. In your submission, you indicate that that in the mechanistic side of things probably won't take much of anything. Mechanics, you look at it and come up with that. But you do indicate that when there is additional fact finding, it would not be unduly burdensome to the system from your perspective. And, you know, you've sat as a trial judge and you sat on a court of appeals to review some of these decisions that might be made by courts. Tell us what your view on that is.
I think there are really a couple of things that happen when you're confronted with this situation, right? You're a district judge and there's a question of fact that's been presented. And, you know, when it's all just presented on paper, I think that, and circuits vary in what they allow people to do. But in our circuit, you know, if the district judge said this fact question has been presented and it is unresolvable on the PSR that we have accepted, right? Because once you accept the PSR, that's a statement of facts. It is what it is, right? And you'll say, okay, this fact isn't in there, all right? And I think an awful lot of judges are going to get to the point where they're going to say, doesn't matter to me, because under 3553A, I'd arrive at exactly the same sentence, right? Because whether the loss was directly caused by the defendant or whether the loss was just indirectly caused because he participated in a conspiracy that cost people $1 million, I think a lot of times you're going to look at that and say, that is a fact that doesn't make any difference to me in my 3553A analysis. Now, there's a requirement that you correctly find the guideline range to start with, right? And so you could make an argument that somehow that's a procedural error, but I will tell you that in looking at how our court, and I think most of the appellate courts have addressed those issues when they come up, they'd say, well, the judge still could correctly say that that fact wouldn't make any difference to me and my sentence would be the same. I mean, we do that in our circuit on all sorts of things. You know, if the sentencing judge states, you know, I don't think that a particular enhancement applies, but even if I'm wrong, I'm imposing the same sentence I would anyhow. And we've said that's okay. Now, I know there's a circuit split on that, but I just would say that my experience would be that when you get right down to the facts that make a difference for the judge's sentencing, that would require and necessitate an additional hearing to acquire new evidence beyond what's put in the papers, I think it's going to be relatively rare, because you're going to be, the way we have this thing set up now, you'll be in the amendments that are in Part B. That's a relatively small number of people. In our district, it was only like 10 or 12 people total. And, you know, it seems to me that holding that hearing would be a relatively unusual experience.
Thank you, sir. Thank you to this panel. Thank you for your testimony. We appreciate you. All right. I'd like to introduce our fourth panel, and after this panel, we'll take our lunch break. But I'd like to introduce them, and they will provide the perspectives from law enforcement officials on our question before the commission, retroactivity. First, we have Chief Eddie Garcia, who was recently elected as president of the Major Cities Chiefs, a professional organization of police executives from across the United States and Canada. He is the 30th police chief of the Dallas Police Department, the 9th largest police department in the country. With nearly 31 years of law enforcement experience, Chief Garcia was appointed in 2021 and is the first Latino to serve in his position in the department's 140-year history. Second, we have he's on the plane. Okay. Second, we have Patrick Yose, who serves as president of the Fraternal Order of Police. With nearly 36 years as an active law enforcement officer, Mr. Yose retired in 2020 from the St. Charles Sheriff's Office in Louisiana, where he had oversight of the department's Special Services Division, responsible for a number of community outreach programs. During his career, Mr. Yose worked as a patrol deputy, patrol sergeant, school resource officer, and detective in the Criminal Investigation Division. Mr. Garcia, we're ready to hear from you, sir.
I currently serve as the Chief of Police in Dallas, Texas. I'm also the President of Major Chiefs Association, and it is my honor to testify on behalf of my MCCA colleagues. My testimony will provide a local law enforcement perspective on whether Parts A and B of the Commission's 2023 Criminal History Amendments should be applied retroactively. The MCCA generally does not support retroactivity, as the criminal justice system needs some degree of finality to operate properly. The limited circumstances where retroactivity may be appropriate must be narrowly scoped, address pervasive issues such as a historical shortcoming in the criminal justice system, and focus exclusively on non-violent offenders. The MCCA strongly believes that Parts A and B of the Commission's amendment do not meet these criteria, and as a result should not be applied retroactively. Part A of the amendment deals with the impact of status points. The MCCA is concerned that retroactively applying it will provide relief to violent offenders and offenders who are high risk at recidivism. Commission data indicates that if Part A is applied retroactively, 11,495 offenders would be able to seek a sentence reduction. This includes offenders convicted of drug trafficking, firearms offenses, robbery, child pornography, sex offenses, murder, and kidnapping. Many of these offenders also are at high risk of recidivating. As status point offenders, they already have a history of doing so. Furthermore, 91% of these offenders fall into criminal history categories 3 through 6. According to a recent commission study, the rearrest rate for these categories is greater than 60%. Let me be clear, if the commission does move forward with retroactivity and an offender who is released as a result recidivates, MCCA members and our local law enforcement colleagues will need to act to keep our community safe. The concerns about violent offenders and recidivism are less applicable to Part B of the amendment, which pertains to zero-point offenders. However, the MCCA has additional concerns and does not believe Part B should be made retroactive either. Making Parts A and B of the Commission's amendment retroactive will make thousands of additional offenders eligible for release within a year, many of whom could be released immediately. The MCCA believes this will create several implementation challenges. For example, post-release supervision services, which are already stretched thin, will likely become overwhelmed. There has also not been sufficient investment in reentry services to handle an influx of new individuals who require them. These services assist individuals reentering society with meeting basic human needs, such as securing food and housing, obtaining health care, and assessing economic opportunities. When these needs are met, it helps address the root causes of criminal behavior and prevent recidivism. Instead of releasing additional offenders via retroactivity, the MCCA believes we should focus on ensuring those who have already been released do not recidivate by adequately and appropriately preparing them for life outside of prison. Over the past few years, communities nationwide have struggled with increased violence and violent crime rates. According to MCCA data, in the first quarter of 2023, homicides were up over 50% and aggravated assaults up 34% compared to 2019. MCCA members have reported that lack of accountability within the criminal justice system is contributing to this trend. The MCCA is concerned that making Parts A and B of the Commission's amendment retroactive will exacerbate these challenges. Making tens of thousands of convicted offenders, many of whom are repeat and violent offenders, eligible for a sentence modification will, without question, contribute to the notion that the criminal justice system is simply not holding people accountable. In closing, while ongoing evaluation and assessment of federal sentencing policy is important, a different analytical lens is required when determining whether a policy should be applied retroactively. The MCA encourages the Commission not to make Parts A and B of the 2023 Criminal History Amendment retroactive, as doing so will be detrimental to public safety. Thank you again for the opportunity to testify, and I look forward to any questions you may have. Thank you.
Thank you, sir. Mr. Yos.
Mr. Chairman, Madam Vice Chairman, members of the U.S. Sentencing Commission, my name is Patrick Yos, and good afternoon. Just looking at the time here. I'm the National President of Fraternal Order of Police, our nation's oldest and largest rank-and-file labor organization, representing 367,000 members from every region of this country. I want to thank you, Mr. Chairman, and the rest of the Commission for inviting me to share the views of America's rank-and-file law enforcement officers on potentially applying Parts A and B of the 2023 Criminal History Amendment retroactively. Specifically, Part A of the amendment reduces the impact of status points for offenders, and Part B provides a decrease of 2 levels of the offense level for offenders who did not receive criminal history points and whose offense did not involve specific eligibility criteria. The Commission is statutorily required to consider whether both parts of the amendment should be applied retroactively to current offenders sentenced previously. The Fraternal Order of Police opposes the retroactive application of both parts of the Criminal History Amendment. Our rank-and-file officers put themselves in harm's way to investigate, arrest, and assist in a conviction of these offenders who were justly sentenced under the rules promulgated by this Commission in accordance with federal law. The offenders knew what the penalties might be at the time of they committed their crimes. The prosecutors charged and convicted them under existing rules, and they were sentenced under guidelines that were then in place.
This is our system at work, and its results, under the rules in place at the time, are just. I recognize that our criminal justice system is not static, and that our system, like any other system, has to be periodically adjusted so that the results are fair and just. It is imperative, however, for reasons of justice and continuity, to apply such adjustments prospectively and not second-guess, reconfigure, or relitigate prior results. The sentence for offenders currently serving time were fair and just at that time. We must also assess the impact of the retroactivity will have on safety of the public. The American public is currently experiencing a nationwide spike in crime. All across the United States, communities are seeing the real-life consequences and feeling the immense pain caused by a recent surge in violent crime. More and more citizens in our country are justifiably living in fear, constantly wondering if they too will become victims. In too many of our communities, the rule of law is set aside in favor of so-called reforms or to advance reform agendas. This is creating greater danger for the streets in our communities. We need to find strategies that improve the criminal justice system and reduce crime and reject policies and practices which do not prioritize public safety. The Fraternal Order of Police does not believe that the retroactive application of Parts A and B of the Criminal History Amendment will do that. According to the Bureau of Prisons, there are 50,545 currently incarcerated offenders who are assigned status points. Of these, 20,598, 40.8% of the total, have been assigned a criminal history score of 6 or lower when they were sentenced under the existing guidelines. If Part A is applied retroactively, and a criminal history score of these offenders were reduced by 2 points, and the scores of the other 59.2% of offenders would be reduced by 1. This would result in approximately 11,495 of the 50,545 status point offenders being eligible to petition for a reduction of sentence. According to the Bureau of Prisons, the average sentence for these offenders is 120 months. If the courts were to grant a full reduction possible in each case, the new projected average sentence for these offenders would be 106 months, a reduction of 14 months. More than 3/4 of the eligible offenders could be released within the next 5 years, and approximately 2,000 eligible for immediate release. This will have a considerable impact on public safety. Similarly, we oppose a retroactive application of Part B, which would apply to offenders with 1 or more criminal history points. The Criminal History Amendment provides a decrease of 2 levels of the criminal history category with sentencing table for these 0-point offenders. The Bureau of Prisons estimates that there are 34,922 0-point offenders incarcerated in federal facilities, of which 12,574 meet the additional criteria established in federal law. More than half, 57.8%, or 7,272 offenders, would have a lower guidance range if the Commission were to make Part B retroactive, and therefore would be eligible to seek a modification of their sentence. According to the Commission's own data, the current average sentence for these eligible 0-point offenders is 85 months. If the courts were to grant a full reduction possible in each case, the projected new average sentence for these offenders would be 70 months, a reduction of 15 months. Approximately 1,200 offenders would be eligible for immediate release. We know that our criminal justice system struggles to integrate released offenders back into society. From the perspective of law enforcement and public safety, these challenges include a lack of communication within state and local authorities when an offender's release date is changed and they are released back into the communities we protect. We must also consider the resources needed to make absolutely certain that victims are notified of an offender's release. The resources of the United States Probation and Pretrial Services were severely strained during the Obama administration and Clemency Initiative, and more recent in the implementation of the First Step Act. The Fraternal Order of Police is very proud of our work in enacting the First Step Act, one of the most sweeping and comprehensive changes in a criminal justice system in decades. However, we strongly believe at that time that greater resources were necessary, especially in personnel, to ensure that the release of offenders would have the support they needed to maximize their chances of successful integration back into communities. Unfortunately, those resources were never materialized. The First Step Act has only been in place for 5 years, and a prisoner assessment tool targeting estimated risk and needs, better known as pattern, which measures an offender's rehabilitation during incarceration, already provides an opportunity for inmates to expedite their release. We believe that the Bureau of Prisons and the federal criminal justice system is doing everything that it can to ensure that the ultimate goal of integrating former offenders into law-abiding society is met. The Fraternal Order of Police sees no compelling reason to apply Parts A and B retroactive as they do not correct an injustice. In fact, quite the opposite. They change the rules after a just result is simply unfair to victims. I want to thank the Commission in advance for the consideration of the views of 367,000 members of the Fraternal Order of Police, and I'd be pleased to answer any of your questions. Thank you.
Thank you, Mr. Yos. Any question of these panel members? Yes.
Thank you both for your testimony, just as an initial matter. But you both spoke about issues with reentry and with supervision. The probation office and the Department of Justice, the BOP, have asked us to sort of delay implementation if we do this to 3 or 6 or 9 or 12 months to give time for probation and reentry services to be ready to be up and running. Would that alleviate or mitigate to some degree your concerns about public safety, or not really?
You know, I'll take the first stab at this. You know, even in the current system right now, we're seeing significant failures in the post-supervision of individuals, whether that be the monitoring on ankle monitor or work for violent criminals. And so I'm not quite certain that any months are going to fix the failures that we're already seeing under the existing policies that we have. And so, you know, up until the point that, you know, even let's fix how we're working on now, you know, before really moving on to others, because we're already seeing significant true life stories and failures and victimization and recidivism currently under the current system.
Yeah. And I'll add, maybe it's not specific to your question, but it's something that should be considered as well. The vast majority of law enforcement in the country are local and state agencies, and we're in an existential threat right now in personnel in trying to attract the next wave of law enforcement. Pretty much every agency in this country is working shorthanded. This just puts even more burden, maybe not directly to your question, but something for consideration.
Mr. Yos,
Yes, ma'am.
you stated that FOP supported the First Step Act, but that unfortunately resources for community reintegration that you described as necessary for implementation did not materialize. I was just hoping you could flesh that out.
Well, I think, if I could, I think our previous panelist identified it quite well, that the resources are necessary in order to be able to do the adequate job or something of a strain, even today. So at that time, you had an influx of requirements on the probation and sentencing to process all of these applications, and I just feel that it's going to create a similar situation.
Chief Garcia, I want to follow up with to a response that you made about failures in the system with respect to, and I know you from Dallas and from Texas, so I just want to know if those failures that you've seen are as a result of a failure in because as Mr. Yos mentioned, there are more than one system of criminal justice systems, local systems versus federal. Are you talking about the failure specifically in the federal system of recidivism and failures of persons who were who had been convicted of federal crime vis-a-vis failures of persons who might have been under supervision under various local or state systems?
Sir, we've seen failures in both, quite frankly. We've seen failures at the local level, at the state level, and we've also seen failures at the federal level with individuals that simply have not, that the systems and the infrastructure has not been in place to be able to supervise them properly, as to whether it's post-release or pending trial for certain things. We've seen the supervision failures on both sides.
Okay. All right. Thank you.
Gentlemen, just I'm very curious to your expertise on with respect to folks coming home and the systematic failures you've identified. What should be done to improve somebody's chances of successful reintegration that's not happening right now?
That's a great question, Commissioner. One of the things in Dallas that we're doing, and it's been implemented nationally too, is with our focused deterrence model as an example. And understanding two things. Number one, preparing individuals. The time to prepare individuals that are coming out of custody is not when they come out of custody. We need to do a better job of preparing them prior to that. Obviously, simple things, making sure they're able to get their driver's license, their IDs, getting them back with regards to financial credit cards, making sure that we have systems in place that if individuals need help with job training, education, not just for them, but their families as well, that they're given those opportunities. And the thing is, in particular in Dallas, and I would imagine that this is nationally, there's a lot of hands ready to help in that dynamic. And so really it's reinvesting in people and places, but also understanding and giving a clear message to individuals. We will not tolerate violent crime. We will use every tool we have in our toolbox to ensure that these individuals do not hurt our communities. Is one of my good friends and an urban specialist, his name's Anton Lucky, and he's told me many times, sometimes people need prison ministry if they're not going to listen. And to ensure that those individuals aren't hurting our communities, and ensure that we have a no tolerance for violent crime, and that the individuals that do want help, that we're able to provide that help. Because if they don't get the help they want, and they do recidivate, and they do end up going back to prison, it's because someone else in our community has been victimized. And so I think more needs to be done in the preparation of these individuals coming out of incarceration. More needs to be done with not just letting them out and not having wraparound services available to them for the simple things. I know we jump immediately to getting them jobs and job training, but if individuals can't have an ID, if individuals can't start some sort of credit, they're going to be back on that conveyor belt to prison. And so those are some of the things I think we need to do collectively.
I'm not too sure I can improve on that, other than to say that every dollar we spend and every effort we spend in order to be able to break that cycle of violence, that cycle of crime, is a dollar well spent. I think it's very obvious, at least in my 36 years of law enforcement, that the vast majority of crime is committed by a small percentage of people. We take them off the streets, we stop the crime, we put them back on the streets. Potentially, if we don't break that cycle, it's going to continue. So that is the big question, one that I'm sure there'll be commissions for years. We'll be asking that same question, and I'm not sure we'll ever fully wrap our arms completely around it until we're invested in making sure that we take those steps to break the cycle. Thank you.
Vice Chair Murray?
One of the questions that's been coming up a lot is what role, what purposes did status points serve when they existed in full? And obviously one of them was specific deterrence in terms of, and that was to some degree undermined by research on recidivism. But another question that's come up is, how much of a role, how much did the fact of having reoffended while you were on status, especially in the state system, reflect a lack of respect for the law or an increased culpability? And I'd love to hear what both of you think about state supervision. How often is there a state or local offender who doesn't even really understand they're on supervision, or doesn't realize that it has not been conveyed to them that it's really a big deal not to reoffend while you're on supervision?
Well, I think we probably have a lot to say on this, but I'd say it matters greatly, I believe, from the accountability piece. One thing that I think is out there that we don't talk about either is, and I'll just say there's been a demoralization of law enforcement nationally with respect to honorable men and women that serve and sacrifice for the community, knowing and thinking that individuals that are committing crimes are getting more chances than our victims, and that the rule of law has become less. And that has led to a lack of engagement in communities in both ways, right? Where the law enforcement's on one end, the community's on one end, and there's no one in the middle keeping our community safe, because there's been a perception that the rule of law has decreased. And that has to be spoken about, because as changes are being made to our criminal justice system, we have to remember that the boots on the ground, the honorable men and women that are sacrificing every day, that they're doing it for something, that they're doing it for a reason. And that does impact our men and women nationally. And that has led to an increase in violent crime in the country, because honorable men and women in this profession have disengaged from communities, and that is a fact. I'll say that, from a local level, individuals do know, right? And so the lack of the consequences with respect to individuals that have committed crimes while on supervision, that, there's several horrible examples that I have locally in Dallas, and I'm sure nationally, that really tend to the fact that the infrastructure simply is not put in place to supervise these individuals properly. And then when we're dealing with violent criminals, the post-supervision simply is not enough oftentimes. And so it's incredibly important for us to continue to build on those other services to ensure that if individuals have been held accountable, and if the process is that they are to really be released, whether it's pre-trial or post or what have you, that the proper systems are in place to supervise them. Because we've seen many examples when it's not done right. We've seen some heinous crimes being committed, and then I have to look at my community. And again, we're always a front, right? Our community oftentimes thinks that the police departments are the only cog in the wheel. We have to spend time explaining to them that we're not, right? And so it's very difficult to look at our communities that are getting impacted by violent crime when individuals then commit these heinous crimes when, the question is asked, well, why weren't they held accountable the first time? And so it's incredibly important to us. I know it's incredibly important to my neighborhoods and communities that are impacted by violent crime as well.
I just echo exactly what the chief said. There's no question the last few years have been a challenge for law enforcement. The very powers that law enforcement officers have are directly related to trust in their community. If we know anything in the past few years, that trust has been really, really pushed to its limits. As sort of an adversarial relationship where law enforcement, who's called upon to do everything and handle everything, is put in a position of a really poor light. So that lack of respect certainly has had an impact. I will maybe shift it a little bit and just answer it in a little bit different direction. I think if we look across the country and we see those communities where all of these spokes in that wheel are working together, all the resources are in place. If you look at those communities where everyone has a vested interest in the well-being of a community, we see thriving communities. In places where we see fractures, I think that's where our problem comes in. And I think that's where I expressed the concern of the resources necessary in order to effectively do this. While we may be talking about sentencing on a federal level, all of these offenders are going back into local communities. So it's much bigger than just a federal picture. It affects every one of our communities, and there needs to be more resources. Everyone needs to be working together on all of those folks in order to provide healthy communities.
Not infrequently, I think district judges get motions for early termination of supervised release from probation offices. Supervised release terms can be very long. It can be resource intensive for the probation officer. And one thing I'm hearing in your testimony is interesting because there's been a lot of focus in the testimony before you on sort of the modification of actual sentences. But is what you're getting at also that with a greater pool of people to supervise, you might also see a lot of motions to modify or terminate supervised release as well on the back end, and therefore sort of less supervision with more people to supervise?
I would absolutely agree. I mean, again, as I mentioned earlier, I hate this, the way the system is currently set up is not working very well. And so, yes, this will absolutely add to that burden in my opinion.
I agree.
Well, thank you, gentlemen, for your testimony, and I hope you are able to get another flight or something, Mr. Garcia. Otherwise,
I already
DC will
changed it.
keep
It's
you
all
here
right.
for a day.
I'm open to more questions. I already changed it, so.
You're a guy from Dallas. You can handle it, huh?
Thank you very much.
Thank you all so much. All right. All right. We're now going to take our lunch break. I asked that, we got behind this morning. So we'll start back up at 2:10 this afternoon. Thank you all. We're in recess. Welcome back. I hope everyone enjoyed their lunch. We're ready for the last half of this hearing. Today, we have two panels left. The fifth panel will provide us with community perspectives on retroactivity. Our first panelist is Mary Price, who serves as General Counsel of FAM, a national nonpartisan advocacy organization that focuses on criminal justice reform. Ms. Price is the founder of the Compassionate Release Clearinghouse, which recruits, trains, and supports attorneys to provide pro bono representation to people in federal prison seeking compassionate release. Ms. Price also serves as a special advisor to the American Bar Association's Criminal Justice Section and as a member of the National Association of Criminal Defense Lawyers First Step Implementation Task Force. Our second panelist is Alan Weingrad, who serves on the board of the Center for Justice and Human Dignity. The center aims to reduce prison incarceration while improving prison conditions. Mr. Weingrad is a former United States Attorney for the Eastern District of New York and currently works as a senior counsel in Covington and Burling's white collar defense and trial practice groups. Finally, we have Frank Russo, who is Associate General Counsel and Director of the American Conservative Union Foundation Prosecutors and Law Enforcement Advisory Council at the Nolan Center for Justice. Mr. Russo previously served as the Director of Government and Legislative Affairs at the National District Attorneys Association. He also worked with the House Judiciary Committee and the Senate Judiciary Committee. Before we turn to Ms. Price, I want to announce, and for those who are watching, we have been joined, I guess, not just in spirit, but personally, by Commissioner John Gleason. So, Ms. Price, you may start. Yes, we can. Yeah.
Now I'm on.
I can hear you because I'm right here with you. We need them to hear you.
Thanks a lot. Good afternoon, Chair Reeves and Vice Chairs and Commissioners, and thank you for the invitation to testify today in support of retroactivity of Parts A and B. You've heard a fair amount today about how magnitude and purpose and manageability support retroactivity, and we agree with that. Equally important, we believe it's required in the interest of justice and fundamental fairness. The Commission's had a long-standing commitment to identifying and amending the guidelines to address demographic and racial disparity, and that history should inform this decision. The Commission has found that status points are disproportionately assessed on people of color. More than 70% of people eligible for retroactivity are people of color. And people of color make up 83.1% of individuals eligible for 0-point adjustments where they made retroactive. The disparate impact of status points and the treatment of 0-point defendants offends fundamental justice and fairness. Several prior retroactivity decisions explicitly address the racial delta of the crack cocaine disparity. There's hardly an argument against making this particular disparity of criminal history scoring retroactive today. It's true that widespread knowledge of the crack powder structure undermined confidence in the fairness of the criminal justice system, but this Commission does not take its cues from public opinion polls. The Commission's retroactivity analysis has exposed a somewhat hidden issue in terms of disparity. It's no less egregious because it's hidden, and a hidden disparity is still a disparity, and now in plain sight it should be addressed. I want to talk a little more about magnitude. This is not a minor downward adjustment. Unquestionably, the number of people affected and the time saved show that the magnitude test is met. But magnitude of retroactivity can also be measured in a different way, in a most personal and intimate way. You'll hear in the next panel from people who benefited from retroactivity decisions of the Commission. But I want to share with you the words today of people who are still incarcerated. I wrote to our members, we have membership in the BOP, I wrote to our members in the BOP recently and asked them to tell me in a few words what a day in prison means compared to a day of freedom. I'm going to share some of those comments with you now. Deshaun said, "A day in prison to me is like boulders on my shoulders. Every step it's getting harder and harder, and it feels and means to me that I'm losing my true self every day more and more. I'm becoming institutionalized, and that day in freedom would look like everything to me." Marty said, "A day in freedom would entail doing something I love, surrounded by those who love me. When I get done with work or school, I could go home, I could have dinner with my family and talk about our days. Instead of having to call them and not having enough time to talk to everybody or really understand or be a part of what they're going through. A day in freedom would mean more than I can ever put into words for you." I also asked them what a reduction in 14 months would look like to them. And Jimmy said, "Well, most people would think 14 months off my sentence is nothing big, which is easy, except from the outside looking in. However, in my shoes, I would take this and be very grateful for it because it would put me closer to freedom, family, and a chance to show all those I hurt and affected and my victims that I am changed and possibly make those I've hurt proud of who I am now." Marty said, "If my sentence was shortened by 14 months, I'd be able to attend my son's high school graduation after missing his childhood due to my sentence. I'd be able to have this one piece of his childhood to be able to take with me into a future at home. It would mean the world for me to be able to do this as a mother and to have him here with me, not only as we start this new life together, but to be able to have just one milestone memory with me in it." And finally, Aaron said, "When I was locked up, my son was only 6 months old, and now he's 12, and I owe him for my mistakes and the decisions that left me in this situation. With that in mind, in order for me to be the best me and the best father, I know I need to take care of all the things that lead in that direction. Jobs, housing, relationships, and all the things that make up a healthy and productive person in society and in his life. And that's what I would do with 14 months. That's what I would do with a 14-minute head start." So I share these reactions with you because thousands of people, good people, just like these people, are serving sentences that the Commission can no longer justify as needed to advance the purposes of punishment. Judge Reeves, you opened the hearing earlier today and talked about the moral cost of incarceration or moral cost of incarcerating somebody for longer than they deserve. I'm confident that the Commission will not lose sight of the very human impact of the decision that you're going to make today. Thank you.
Thank you, Ms. Price. Mr. Weingrad.
Chairman Reeves, members of the Commission, I'm Alan Weingrad. I'm a lawyer with the law firm Covington and Burling, and I'm here today on behalf of the Center for Justice and Human Dignity. Previously, I worked for the Department of Justice for a total of 12 years. The Center supports retroactive application of the 0-point and status point amendments. Both of these amendments are data-driven, measured, and sensible reforms that will ensure greater fairness in the treatment of defendants in the federal criminal justice system. The 0-point amendment is a conscious effort to better tailor the amount of punishment to the history and characteristics of the defendant. In other words, a data-supported judgment that 0-point defendants should not be punished as harshly as their 1-point counterparts, because they do not need to be. It's consistent with the fundamental principle of federal sentencing embodied in 18 U.S.C. section 3553A that a sentence must be sufficient but not greater than necessary to achieve the purposes of sentencing. It is, in short, an important improvement in sentencing policy that deserves broad application, both prospectively and retrospectively. The degree of potential benefit to 0-point defendants also supports retroactive application. According to the Commission's informative and impressive impact analysis, over 7,000 defendants would on average be eligible for a 15-month reduction in their sentences, more than double the less than 6-month standard of 1B1.10. And this is not merely a mathematical point. Every day, every week, every month, and every year of incarceration matters profoundly, not just to the defendants who are deprived of the many features of normal lives, but their immediate families, other loved ones, and others who depend on them, all of whom suffer and often suffer greatly from their absence. For all of them, the magnitude of the change embodied in the 0-point amendment is significant indeed. And the impact on our correctional system also supports retroactive application. It will help free up much needed space and programmatic resources in a still overcrowded federal prison system so that they can be devoted to serving those defendants who need them most. This will enhance the opportunity for meaningful rehabilitation, which in turn will help reduce recidivism, and it will save hundreds of millions of dollars. Applying the zero-point amendment retroactively should not present an undue burden on the system. Determining whether the amendment's exclusions apply will, of course, add a step to the eligibility determination, but district judges will have plenty of guidance from the commission, from the case law, and importantly, from the case file itself to assist in that process. The commission's own experience with the Crack -2, the Fair Sentencing Act, and the Drugs -2 retroactive amendments supports that retroactive implementation of the zero-point amendment should be well within the capacity of the criminal justice system to handle. Each of the 1B1.10 factors also supports retroactive application of the status points amendment. The effect of the amendment is to eliminate an instance of excessive multiple punishment for the same conduct and to reduce racial disparity in sentencing. Worthy substantive reforms that deserve broad application. The magnitude of the change is substantial, with over 11,000 defendants eligible on average for 14-month reduction in their sentence, and implementation will be even easier than the zero-point amendment since it requires only a potential recalculation of a defendant's criminal history category with no exclusions. Finally, retroactive application of both amendments can be achieved consistent with the goals of sentencing. Reduction of a sentence can only be granted after consideration of the 3553A factors, including providing just punishment and protecting the public from further crimes. These are not empty platitudes. Experience has shown over and over again that district judges frequently deny motions by already sentenced defendants for reductions in their prison terms, even when they qualify for the reduction. This is empirical proof of what is already understood to be true, that district judges can be trusted to implement retroactive guideline amendments responsibly, with due regard for the various competing considerations. And so in the end, if the system ends up temporarily working somewhat harder to implement commendable sentencing reforms that will improve the criminal justice system and the lives of tens of thousands of individuals directly and indirectly affected by it, it is well worth it. Thank you.
Thank you, Mr. Weingrat. Mr. Russo.
Thank you, Chair Reeves, and I greatly appreciate the opportunity to be here today, and we're thankful for the coveted spot after lunch, so we'll try to keep our comments as short as possible. First of all, members of Commission, thank you for having CPAC here today. Many of you know CPAC as the Conservative Political Action Committee, but we also operate the Nolan Center for Justice. Within this Nolan Center for Justice, we are dedicated to fostering conservative leadership on criminal justice initiatives. We fight for policies that provide the best outcome for both our communities and the individuals who are impacted by the criminal justice system. We strive for results because defunding the police or throwing money at our problems both fall short of the needs of our system and the needs of our communities that are impacted by it. Yes, we believe there are some people that do need to serve long sentences, but there are also plenty of others who deserve a second chance. And this is where you, the Commission, have the power to make a lasting impact, providing that second chance by increasing public safety, saving taxpayer dollars, and investing in the people that you've heard earlier will be getting out and returning to our communities. The purpose of our criminal justice system is first and foremost to protect the communities that these individuals serve. To achieve this, we focus on 4 key principles: proportionality, accountability, fiscal responsibility, and human dignity, maybe the most important. The Sentencing Commission can and is working towards achieving all 4 of these by tailoring its guidance to allow for sentence reductions only in cases where it would benefit public safety and be in the best interest of communities. And applying Part B of the criminal history to amendment retroactively will do just that. At its core, the retroactive application of Part B addresses a limitation in the sentencing guidelines. Previously, as you all know, the guidelines differentiate between 0-point offenders and 1-point offenders. despite a significant difference in their recidivism rates. 0-point offenders, those without any prior criminal history points, are actually 16% less likely to reoffend compared to 1-point offenders. The Commission acknowledged this disparity with Part B, providing for a 2-level reduction for 0-point offenders by considering an offender's recidivism potential. And by doing that, we can ensure that the severity of these sentences align with the actual risk to public safety. It is important to note that these amendments do not establish a blanket reduction, as you've heard earlier. Retroactivity is designed to create a pathway for individuals who meet specific criteria and fall within specific exclusions or outside of those exclusions and have worked hard to earn that sentence reduction. We saw this proven to be effective with the retroactive application of the 2007 crack cocaine amendment, where only 64.2% of the requests that were made for reductions were actually granted. Further, those who did receive a sentencing reduction through those retroactivities did not exhibit a higher recidivism rate compared to individuals who did not receive that reduction or got out on their base time at the beginning. Therefore, history shows us that retroactivity can be successfully implemented without compromising public safety. I mentioned this earlier, but the advantages of retroactivity also extend outside of the public safety argument. They also extend beyond the scope of recidivism. It has the potential to generate substantial cost savings. In the federal prison system, we are well aware that it is expensive to incarcerate individuals, and we must do so carefully and with a scalpel, not with a hammer. As each federal inmate costs taxpayers nearly $40,000 per year, this is something that is on the top of mind of communities across this country. Now consider this. The Commission estimates that the retroactive application of Part B can result in the average sentence reduction of 15 months for over 10,000 0-point offenders. If we do the math, and as my colleague stole from me just a minute ago, that's nearly $500 million in savings. These considerable savings not only alleviate the financial burden on taxpayers, but they allow for a smarter investment in our justice system. The evidence is clear. To achieve long-term reduction in crime, we actually need to address the drivers of recidivism. We need to address the drivers of crime that affect not just the individuals who are incarcerated, but the law enforcement who serve on their behalf. Instead of keeping 0-point offenders for a longer term than needed, those who have demonstrated significantly lower recidivism rates, we can strategically allocate our system's resources towards higher risk individuals. For example, we can invest our resources in education and prison programming. We know that those programs are proven to reduce recidivism. Even more importantly, we know that every dollar that gets spent in prison education and programming saves nearly $4 to $5 in reincarceration costs when those recidivism rates drop. This proves the financial incentive for this work is actually rooted in public safety. Ultimately, when we grant reductions solely based on the fortunate timing of an offender sentencing hearing, it shakes the public's faith in our justice system. We don't make decisions based on polling, but it is valuable that there is and trust in the law enforcement officers, the courts, the probation, and the defense that serve on behalf of these communities. And when people perceive this system as unfair, they are less likely to work with the system and less likely to be beneficiaries of it. The distrust in our justice system, in turn, would undercut public safety. If this amendment is applied retroactively, we are confident that giving certain 0-point offenders the ability to earn a sentence reduction will benefit our communities in more ways than one. By providing narrowly tailored retroactivity that requires a comprehensive review of each individual case, the Commission is ensuring that reducing recidivism is at the core of the work that you do. When we reduce recidivism, one of the things I always think is important is that we don't just use it as a talking point. Reducing recidivism means there's one less case for law enforcement to investigate, one less case that my former profession, prosecutors, do not have to take up. And most importantly, it's one less case that a victim has to suffer because of the failures of our justice system to rehabilitate those that are in its care. Thank you for your time today, and we look forward to any questions you have.
Thank you. Thank you, Mr. Russo. Open this panel up to any questions from my colleagues. Commissioner Gleason.
Red is red, green is green. Okay. Can I be heard right now? Great. Thank you for your, I want to focus my first question. No, I don't necessarily have more than one question, but I want to focus my first question on Mr. Russo. And we applaud your attention to the data and data-driven decisions. We also applaud Mr. Weingrad's applauding of the staff that produced the data. They deserve it. But what would you say to the victims of crimes. They're not always specifically identifiable in federal cases, but often enough they are. And what would you say to them when they push back on your support of making these amendments retroactive?
Absolutely, I can handle it first and then let my colleagues. But one of the things that I think is so important in this process that you all have discussed earlier is the victim input. And victim input cannot just be a sheet of paper that's provided by an underfunded office or the opportunity for that victim to only provide something in passing. They need a valuable, and just as they did at their sentencing hearing, opportunity to speak out in whatever form or fashion is most appropriate. That's one. But two is this, and I think it's something that gets lost in this process. Oftentimes, the healing of those incarcerated individuals can be paired with the hearings of the victim or the healing of the victims that they have caused harm to. When those victims see that those incarcerated individuals have turned their life around, have taken that mistake and that horrible, and I hate when we say it's just a mistake, it is worse for the victim than it is for anybody else in the system when a crime is committed. But when they're able to see that that individual is working towards a better life, oftentimes, and we've seen this in a space that I was involved in my last profession, which is prosecutor-initiated resentencing, where the victim actually becomes invested in the success of the incarcerated individual and vice versa. So there's a healing that occurs from both sides of the process. That won't be in every case, I can't promise that. What I can say is when victims are actually involved in the early release, the individual who has earned, not just every individual, the individual who has taken programming, who has worked to reduce their recidivism rates by improving their life, returning to their families, oftentimes that can be part of the healing process. And so certainly we want victims to have, first and foremost, their biggest voice in this process. But two, we want them to be a part of that healing. And I think there's a process that this can play, a role this can play in that process.
Thank you. Chair Reeves, I do have one follow-up, may I?
Yes, you may.
This may arguably transcend the specific purpose of this hearing, but your testimony puts on the table this reality that a diminution in the federal prison population, and you've identified the average cost per inmate per year. A diminution in the federal inmate population there's no straight line between that and a $40,000 per prisoner per year savings that gets reallocated to the resources that you've identified as maybe a better way of expending those funds. What do you have to say about that issue and the fact that BOP budget doesn't seem to meaningfully track the prison population in this dimension?
It's a fantastic question. Unfortunately, when we also see at the state level and with our colleagues who are just across the street, I would like to say that we like to put pressure on them to make sure that those costs are reinvested in the system. And when I say the system, I mentioned educational programming, but I also want to mention that the staff salaries and overtime pay for BOP staff, for supervisory release staff, for your staff is just as important because it's a system-wide problem. It's not just the programming that's struggling, it's also the cost around it. So to answer your question, I think specifically by freeing up that money, yes, I can't draw a straight line, but what I can do is advocate strongly in other settings or with this commission to our partners across the street to say, we have saved you these costs, but these problems still exist, and they exist because of your lack of reinvestment. It gives us a very strong argument and one that I think we need to continue to make regardless of what cost savings end up looking like.
Thank you, sir.
Commissioner Wroblewski.
I thank you very much, Mr. Chair, and thank you all for being here and for your written submissions. In the past, for basically the history of the commission, retroactivity has been the exception and not the rule. And it seems pretty clear from both the Sentencing Reform Act from 994U and from the legislative history that Congress intended for the commission to make a decision, and that there were going to be certain kinds of changes that would reduce sentences that would not be applied retroactively. From what I heard from your testimony, it seems like all of the arguments you're making suggest that every reduction should be made, or nearly every reduction should be made retroactively. The very moving testimony from folks in prison, that's going to be true in every case where there's a possible reduction. Everybody would like a head start. If my family were in prison, I would want them to have a head start coming home. Judge Keeley's comments that you quoted from the Criminal Law Committee about it shouldn't matter what day, that's going to apply in every single circumstance. And there were a number of other things that were mentioned in terms of cost savings and other arguments. Those are going to apply in every single situation. I'm just curious if you can articulate, what do you think Congress had in mind for the commission to do? What are the kinds of decisions that, when the commission has reduced a sentence, would lead to a no retroactivity? And specifically, go back to the recency amendment that was made some years ago. Do you think just the commission was wrong on what they did there? Or can you make a distinction between the recency amendment and the one that we're faced with now?
I can start with your first question and maybe defer to one of my colleagues for the recency amendment discussion. I actually did, it was mentioned, I think earlier, I actually went back and looked at the summary of each and every guideline amendment that this commission has made retroactive. And my takeaway from that is that these amendments are much more in line with or consistent with the recent amendments involving crack -2 and drug -2 and the Fair Sentencing Act, in the sense of being data-driven to correct true unjustness or disparity based on empirical evidence and the experience of the commission, not some refinement of the process or improvement in the way that guidelines are administered. There was a substantive fairness element and component to them that I think puts this in that group of the amendments as opposed to many of the other ones that I read. There's the magnitude element. I mean, I'm really just, the guidance is right in the commission's guidelines. It's in 1B1.10. The magnitude of the amendment, it's all data-driven. You've done a terrific job of estimating down to the person how many people will be eligible. It's significant by any measure, but not overwhelming. It's a good balance. It's the sweet spot, as somebody said this morning. Significant enough to make a difference and to warrant retroactive application, but not so much that it will overwhelm the system. And to the extent that people will get more than a year off of their sentence, well, that's more than the threshold that's in the guideline commentary. And in terms of administratability, I think the case has been made well that, the system has been there, it's done it time and time again. I would hearken back to my previous life as a prosecutor, and things like this would happen. It may not have been retroactive guideline amendments, it was worse. It was Supreme Court decisions that would then lead to a flood of 2255 motions, not only asking for changes in sentencing, but even attacking convictions. So it was even more significant and more substantial. And what did we all do? We worked harder and we got it done. And when I say we, I mean the prosecutors, the defense lawyers, the courts, sometimes probation, and we got it done. If you had to spread, those responsibilities throughout the U.S. Attorney's Office, we did that. There was one of those occasions where there was this, big decision where we had to kind of shoulder the burden of the work that was going to follow, and everybody in the office, line people, assistants, criminal chiefs, and everybody in between rolled up their sleeves and took that burden and got it done. And if that's what's necessary here to further and achieve the kinds of criminal justice sentencing smartness and reform that's embedded in these amendments, the system should shoulder that responsibility and should be happy about it. I suspect there are a lot of judges out there who may not say it, but quietly think to themselves, this is a step in the right direction.
You won't find me supporting or defending the recency decision that was made.
Is your microphone on, Ms. Price?
Yes, it is.
Let's bring it a little closer.
How's that?
How's that? Okay. Good.
Sorry. I started to say that Commissioner Robuski will not expect me to defend the recency decision that was made. I think it was wrongly made. There wasn't a hearing about it, I'm pretty sure. We participated in the comment period and explained why we thought the recency amendment ought to be made retroactive. We talked about the purposes and the impact and the magnitude, and all of those support this here. But what we didn't talk about, and it's a shame, is none of us really looked at what the demographic disparity was. 80% of the people who would have been affected had recency been passed were people of color. And I do think that that has been not a limiting principle to this commission, to any commission, but it's been an illuminating principle when looking at some of the past history. And so that's why I talked about it here today, because I don't think we've talked enough about how this isn't just a minor adjustment, both on a very personal level, but also just looking systemically, that this is, the commission has identified for us ways in which criminal history overstates seriousness or lumps together people who do not share a recidivism risk with their one-point counterparts. So, yeah, I mean, recency was, I think, wrongly decided, and I hope that it's not the touchstone for what you decide to do. But that's why I wanted to bring in, and it's a shame because we should have raised that issue, but nobody considered it at the time. And all I could think of was that we were in the midst of several crack cocaine reduction periods, one on top of the other, and we were pretty laser focused on it.
May I follow up? Mr. Weingrad, you mentioned going through and cataloging kind of all the different sentence reduction amendments that the commission's made, and some fell on the substantive fairness side of the line, some felt more like refinements, and this felt to you more like a substantive fairness issue. Which ones did you think were refinements?
I mean, I can't delineate them for you. They're in my book here. I suppose I could follow up and do that, but they were more of the kind of the procedural variety, I guess is what I would say, and didn't deal with sort of, data-driven information that showed that, recidivism was not being achieved by these greater punishments in these categories. They certainly didn't have, to my eye, from what I saw, any goal or effect of reducing the pronounced racial disparity in some of the sentencing adjustments that were promulgated. So those things, it was more not so much what they did, but those elements, to my eye, were missing from those. I see them in some of the more recent amendments that have been given retroactive application.
Vice Chair Murray.
Thanks to all three of you. I guess I'd like to follow up on recency a little bit. I very much appreciate FAM's view that recency was not decided correctly, the retroactivity issue. But the commission at the time did think it was very clear, right? They, Justice Jackson, Chief Judge Howell, both voted along with the entire commission to say they didn't even need hearings on recency. It was so clear that recency should not be retroactive. From where I sit, recency looks a lot like status. I mean, it's also driven by a new report saying that the enhancement is not tied to recidivism as closely as people thought. It has a similar racial impact. The numbers are similar in terms of numbers of potential filings, percent of filings likely to be granted or eligible. If we don't agree with FAM, like if we think that the commission was right about recency, or we just think that commission precedent matters, is there a way to distinguish those two, or should we vote against retroactivity? So I guess that's a question for Ms. Price and Mr. Weingrad.
Well, I wouldn't encourage you to vote against retroactivity coming from my position. And I'd want to think a little bit more about distinguishing them otherwise. I feel like we didn't have the opportunity to have a hearing, and you've asked for a hearing on this. So that says something to me about how seriously you take these 18,500 people and their appropriateness. So, I mean, that's one signal to me. This is a new commission. I agree that precedent is important, but we learn from our past not only how we should operate in the same ways, but sometimes how we need to distinguish ourselves and do something different. And I think I'm asking us to look at one more piece that we didn't look at in recency, which is that there is a genuine racially disparate impact or demographically disparate impact that going forward you're going to do something about correcting. And I can't see a principled reason why we wouldn't want to make that change available to the people whose experiences you learned about and learned from when you drew the data and you looked at the individuals. So I'm not going to be very much help on that side of it, but thank you.
I have a question, Mr. Weingrad, and then one to the panel. I'm not sure when you were the U.S. Attorney in the Eastern District, Mr. Weingrad, if you were the U.S. Attorney at any point in time during these other iterations of crack -2 or anything like that?
Before.
Oh, before, because I was going to ask about what process your office might have used in doing. Are you aware of the process that the office used in handling those motions and
No,
cases?
but I am very familiar with the process that was used in what I would describe as analogous situations where there was some legal pronouncement that caused a whole raft of, motions and petitions and the like from a significant number of the defendants who have been prosecuted, and the manner in which those were handled and dealt with the Federal Defender's Office to kind of have a process by which those would be addressed. Certainly within the U.S. Attorney's Office, I mentioned before, whether it be an assignment system, whether it be relying upon people who did our appellate work or some combination of them to be able to address them in an efficient way. But essentially, we got the system to work and to do so efficiently, where it didn't, overwhelm the office from my own perspective. I mean, I personally did some of those matters. I wasn't happy about it, but I did it. And I never felt that it was interfering with my ability to carry out the rest of my responsibilities. And as I said, I mean, now we have a track record, not mine, but the track record of the 3 recent retroactivity amendments. And I think this commission has heard and read a great deal of testimony from different people, the punchline of which is this can work and it won't bring the system to a halt. I think the estimate that you received from the Justice Department seems significantly overstated when you compare it to the data of past retroactive amendments to see how many motions were actually filed compared to the number of people who are eligible.
The other question, which again pivots off of what we heard earlier today, with respect to whether or not, if we were to make the provision retroactive immediately, 3 months down the road, as POAG might have suggested, 6 months, 9 months, 12 months. This is to all 3 panelists, because you're here talking to us from your perspective. What is your perspective on any delay or how long the delay or whatever? I'll start with Ms. Price.
You and me.
And then, yes.
This somewhat depends on how quickly you make your decision. If you were to make a decision relatively soon, we are months away still from November 1st. That is time in which the parties can prepare for retroactivity. I don't know what your process is, so that may be unrealistic. It's our preference that it start as quickly as possible, immediately, I hope, but given that we have some time here, it feels like that time could be well used in service of preparation and coordination.
Thank you. Ms. Vine?
Yeah, I guess I have a bit of a different perspective. I mean, I think the concern about proper implementation is well-founded. I would point out that to the extent it was suggested earlier that the reentry process starts in prison 6 months before release, there's actually much more recent evidence of that from the Bureau of Prisons itself, that they actually start 18 months before. So there's much more of a lead-up time. Having said that, there's certainly a burden on probation as well. I think that's where the major burden would frankly be in terms of additional supervision. To the extent there will be people released in the short term who will not be held because they're not U.S. citizens and they're not getting out in any event, that reduces the number significantly. But I think, the commission would not be faulted if it built in some modest period to allow all the constituent parts of the criminal justice process to get ready for those who will be released. I'll also say, just going back to the point about victims, I think, the commission could certainly do what it did with respect to the recent compassionate release amendments, where I think it specifically had a provision to ensure that victims got reasonable notice and the opportunity to be heard, which I completely agree with. Whether or not it's, already provided for under 3771 of Title 18, I think the commission would be well advised to explicitly state that, because victims' voices do matter. The Center for Justice and Human Dignity believes that. I believe it, and I know you all believe it, and you should be explicit about that.
Yeah, I'll be very brief. Thank you, Mr. Chairman. And really, I come down kind of on your side, which is I think the burden will fall mostly on supervisory release at this point, as well as, the court system itself will quickly pick up that burden, but the supervisory release system is already under significant pressure, as you probably heard this morning. And so I think it's important to build in, whether that be a 3, 6, 9. I don't want to put an arbitrary number on it. One of the things that I do not want to see happen, I think, from our organization's perspective, is it turn into 12, 15, 18, because then it becomes an excuse for those who may not be in support of this effort to try to push in unique and different ways to hold up its implementation. So I think we've seen that a little bit with the application of some of the First Step Act and the fair sentencing provisions and the drop twos, but I think building in a reasonable amount of time for both the supervisor release end of it to play a little bit of catch up, and then build in the time for the court system to be prepared, which I think in many ways it already is, would be appropriate. But going too long, I think, has a negative impact as well.
Go ahead, Vice Chair Murray.
Mr. Russo, does the Nolan Center have a view on Part A retroactivity? I wonder, given your focus on public safety, if your views differ? Or?
Most of our focus has been on Part B, and I'll kind of outline that. And one reason is that is where our research was in the area of making sure that 0-point offenders were eligible. In Part A, we are not opposed to our partner's view. I think one of the things that we would want to make sure we see is as robust of victims support and services, where you have cases that involve more identifiable victims, more identifiable individuals who may have been a part of some of those offenses, and then making sure that the system, and this kind of gets at the chair's question, which is making sure we build in the proper time to implement those type of processes. Something I saw, and it's more state level, so I'm not picking on my federal partners, is that victim services are in itself within a crisis at the moment of both staff, talent, and attention and time. And so making sure that those processes are able to catch up as we're doing these things is incredibly important, and making sure that the state and federal partners are talking. It's going to be a bigger challenge with Part A than Part B in our mind, but I think the focus on Part B is because we do think there is a clear history of both the Commission's work and of the data side that shows that those individuals will be successful upon release given the proper resources.
And are any of you aware of any legal authority that we have to mandate victim services or notification? Obviously, the CVRA says if there is a hearing, they have to be heard and notified, but outside of that, are you aware of any authority that we have to prescribe that?
I'll say quickly that the VRA does apply, and that both federal and when you have your co-cases, so work through the Attorney General office, you also have your state laws that are going to require basically anything that fits within that. I would say it's important to include in any type of guidance because it's a re-emphasis to both the field and the practitioners that it needs to be a priority. So even though it may not be a legal authority, even if it's just a referral authority, or making sure that it's highlighted as something that the Commission found to be incredibly invaluable and important and key to the success of this process, I do think it's worth including for that reason, because oftentimes it'll be referred to as those cases begin to proceed, the notes and comments that you include in your advisory consuls.
Yeah, I mean, the statute actually uses the phrase public court proceeding. Yeah. So it's a little ambiguous. I suppose, a resentencing done on papers could be considered a public proceeding to the extent the filings are public. But I guess putting it differently, Vice Chair Murray, I don't know of any authority that would prohibit the Commission from, in its discretion, stating that judges should give, to the extent practicable, reasonable notice and an opportunity to be heard to victims before they make a determination on a motion for reduction under either one of these amendments.
Any other questions? Panelists, thank you so much for your time today. Judge Restrepo is coming back. I don't want anybody to be worried. He told me he'll be right back, okay? But he did give me permission to go ahead and get started. So our sixth and final group of panelists will provide us with perspectives of formerly incarcerated people. First, we will hear from Jerome Breaux, who currently resides in his hometown of Chicago, Illinois, where he has worked as an independent contractor delivery driver for 3 years. In June 2000, Mr. Breaux received a federal sentence of life in prison for his participation in a conspiracy to possess with intent to distribute crack cocaine. At the time, his final offense level was 44, and his criminal history category was 6. In 2010, after serving 10 years of imprisonment, his sentence was reduced from life to 360 months pursuant to retroactive changes to the guidelines made in response to the Fair Sentencing Act. 9 years later, his sentence was again reduced thanks to the First Step Act, and he was released after serving over 20 years in prison. Mr. Breaux is an active parent to his 5 children and a proud grandfather to his 3 grandchildren. Second, we will hear from Bernard Gibson, Jr., who currently resides in his hometown of Prince George's County, Maryland, where he works as a mentor with Lead for Life, an organization that offers mentoring and reentry services to children. In 1997, Mr. Gibson was sentenced to 324 months in federal prison for participation in a drug conspiracy. At the time of his sentencing, Mr. Gibson had 0 criminal history points and no prior convictions, and a final offense level of 41. In 2017, his sentence was reduced to 262 months pursuant to retroactive changes to the sentencing guidelines. After his release, Mr. Gibson married his high school sweetheart. He is a doting grandfather and social justice advocate who plans to continue providing reentry services to formerly incarcerated individuals. Finally, we will hear from Jeffrey McReynolds, who currently runs a logistics company with his wife. In 2005, Mr. McReynolds was sentenced to a term of 235 months in federal prison after being convicted of conspiracy to possess with the intent to distribute crack cocaine. At the time of his original sentencing, Mr. McReynolds' final offense level was 33, and his criminal history category was 4. Mr. McReynolds' sentence was reduced twice pursuant to the retroactive changes in the guidelines. First, by 84 months for the crack -2 amendment, then by 30 months for the drug -2 amendment. In terminating Mr. McReynolds' supervised release early, the court explained that, quote, he has changed his behavior and remains eager to continue being a law-abiding citizen, close quote. Today, Mr. McReynolds advocates for sentencing reform and mentors others returning citizens on starting small businesses. Mr. Breaux, we're ready to hear from you when you're ready, sir.
Good afternoon, Chairman Reeves and this honorable commission. In serving over 20 years in prison, there were many days and nights that I've begged, pleaded, prayed for the opportunity to speak before a body such as this, to see if something I could say could make a change so that I myself could get released. Unfortunately, I wasn't able to do that. I am humbly here today to say I am here to speak for the people that I left behind, hoping that there is something you will hear from this panel that will get you to yes on these retroactive amendments. I still personally know people that are serving over 30 years. Two names come to mind: Carmen Tate, Eddie Richardson, that have served over 30 years in prison. So I like to give you guys my perspective. My time started in Terre Haute Federal Prison, one of the most dangerous at the time. In fact, I was there when Timothy McVeigh was executed. I was there learning the law, trying to desperately find out, of course, like everybody else there, how I could turn this thing around and get out of prison. Unfortunately, Apprende, United States versus Apprende Supreme Court decision didn't help. The progeny of those cases didn't help because they were not made retroactive. Only after I had served over 10 years did I finally get some relief from a life sentence, and then an additional 9 years did I get relief and come home. In my time there, despite having a life sentence and not knowing when I would come home, I dedicated myself to education, to become better, to prove not only to the people that I had disappointed, first and foremost my wife and my children, but also to the judges, to the prosecutor who spoke glowingly about me and then asked for a life sentence, to prove to them that I am not going to be that person ever again. And to say that maybe with the people that I could possibly touch inside, that I could affect change as well as be change. There are numerous things that are going on in the federal prison that I think you guys need to hear about. We all in there, despite the negatives that you hear, take advantage of every single educational opportunity. Every class, I took everything from real estate to bookkeeping. I even took yoga and calligraphy writing. I wanted to spend as much time engaged in positive activity as I possibly could. And in doing that, believe it or not, more people joined. So they saw, despite the fact that I wasn't getting relief immediately, that it was beneficial to stay engaged in positive activity. It didn't matter what your sentence was because I was surrounded by people with life sentences. I had 2 and I thought I was special. That wasn't the case. I met people with 3, 4, 5 life sentences. Unfortunately, most of those were for what was described by, when I started reading the law, what was described in the U.S. Code as victimless, non-violent offense. And I was blown away because I couldn't understand how I had committed a crime, but there was no violence and there was no victim, but my life was taken away. I am blessed to be before you today to have my life back and be a fine, upstanding member of the community, doing every possible thing that I can to not only not reoffend, but to be the example. There are educational opportunities there that we take advantage of. There are so many things that we need to do in there. And I've seen change over the course of the 20 years that I was in prison. When nobody participated, to there was a waiting list for courses. So I know people are changing. You might want to give them a chance. As well as, and I'm just riffing here, once I was released, and this is going to be interesting, once I was released, I continued that. With those relationships that I made inside, they continued outside. we now have a community. I didn't even find out until last week, Thursday, that Jeffrey was going to be on this panel. But over 2 years ago, we were together at Jeffrey's house with a collection of people who benefited from retroactivity. And we had no idea we would be here today. And none of these people have reoffended. So if you have a worry or concern about whether or not you should vote for retroactivity, what I have to say to you is, please don't let perfect be the enemy of good. Weigh this decision heavily because you affect people's lives. Earlier, in the earlier panel, I heard people speaking about whether or not there should be a delay in starting this. Well, if I would not have received retroactivity, I would still be in prison right now. So when you think about a delay, please take into consideration that people are waiting to get out, put their lives back together, and do good. Not just to benefit themselves, but to benefit others. And when they do good, they make your job easier. They make the jobs of the probation officers easier. I was literally released from probation in 17 months. I was supposed to be on probation for 5 years. Nobody involved. The judge who released it, the probation officer whose care I was under, or the assistant U.S. attorney thought that I needed any more supervision. We may be the success stories that you need to hear. Yes, there are going to be people that reoffend, but I can guarantee you there are going to be more people like us and less people who reoffend. Thank you.
Thank you, Mr. Bro. Mr. Gibson.
Good afternoon to the council. Can you all hear me? Good afternoon. First of all, I just want to thank you all for allowing me to be here. This is something special, like Jerome said, just to be able to come and stand before you and testify to think about those who are left behind. Also, I want to acknowledge my family who's here with me right here, my cousin Michael, my wife, my high school sweetheart who I married. And if it wasn't for retroactivity, that wouldn't have happened. And she's here right here. One of my best friends, the whole 18 and a half years I was there, Melbourne, was there with me. I'm coming from my head because I didn't really write anything down. And I want to thank Murray, Alan, and Frank that was just here, because a lot of the things they said I wanted to say. So today I come as a person telling you that people can change, that people really need a second chance. As you all just heard, I had no criminal history. I had never been in trouble in my life. I was working when I caught this case. I was on a conspiracy case, and we're not even going to get into that part of it, but I was 27, I believe, and I got 27 years. That's just unheard of. I understand that people have to be punished for the things that they've done, but some punishment is just too much. I knew after the first day or two I was incarcerated that I was never coming back to jail again, never. I work right now with a bunch of youth that has been in and out of jail and with Leave for Life, and a lot of times they call me to relate because a lot of the mentors haven't been in the situation, so they can't relate. And one kid wouldn't go to the hospital. You know, it was free, you're getting everything done free, he wouldn't go. But when I came in and shared my story with him, and it was similar to his, you know, he talked about my mom was 17, 18 years old when she had me. Well, my mom was 15 when she had me. You know, we are a product of our society. And I heard earlier where they were talking about disparities and about what would cost this, what would cost that, how much pressure we put on probation, how much pressure. Well, we all know the judicial system and the system in itself is overcrowded. So whether we're doing it in jail, outside of jail, something has to change. It's going to affect either probation or it's going to affect the COs in the jail. If the commission came to the conclusion that these sentences should be lowered, why is it that two people that get charged on 2 separate days get 2 separate sentences because it's a different day? If it's changed, needs to be changed, it needs to be fair across the board. This is America. This is a land of fair and opportunity. So we're going to be fair. Let's be fair. If we don't, we can't leave those behind. Let's show some grace. Let's have empathy for those who are in. Because I know for me, and I heard the thing about the time, how much time it's going to be. My grandmother stood behind me the whole time. And she died 7 months after I got home. So if I didn't get retroactivity, I would have never seen that. She once said to me, Bernard, I hope you hold me before I pass. And because of retroactivity, I made it home 7 months later. Maybe a year or so later after that, my grandfather passed. I lost so much in those years I was gone. And like Jerome said, we learned so much. I took every class. I have a stack of papers from COs saying how great I would be in society. And there's so many people just like me that's doing the same thing. I just went to a funeral, and it was 40 guys there that I was locked up with. 40 guys. Not near one of them has been back. I can't tell you about recidivism anywhere else. I can only tell you in my community. And in my community, these guys aren't going back to jail. These guys are mentors. These guys have nonprofits. They're doing stuff for kids. They're starting their own businesses. With they're back paying taxes. They're home with their families. You take, when you go to jail this many years, you take something special out of the family. It puts a burden not just on, I understand the victims, your family becomes victims too. Because you take a money-earning person out of the family. You take a father. My son was 4 when I left. When I came home, he was 22. I'm still building that relationship with him. It's gotten a lot better, but I'm still building. So I beg of you to look at this thing seriously, to look at the whole avenues of it and understand that this affects a whole bunch of people. It affected my family very harshly. And for me to come home and to be back is a big blessing to my family. And for me to see my grandmother, to be there for her, to see that smile, to say you made it home was a blessing. It's a blessing that if it wasn't for retroactivity, I would have never gotten it. So I ask that we be fair. I ask that we have some empathy for those, and I ask that we bestow grace upon them. And that we give them the same chances that I had to start their life over, to be better, to give back to the community, to give back to their families, because that's what I'm doing. And I'm going to continue to do that. And I'm going to continue to instill that in these youngsters that I'm dealing with each and every day. Thank you.
Thank you, Mr. Gibson. Mr. McReynolds.
Thank you. Thank you, Chairman Reeves and the members of the commission. I appreciate this opportunity to testify before you today. My name is Jeffrey McReynolds, which you all know. I'm Chief Operations Officer of JSM Logistics. I'm testifying as a direct impacted person of the retroactivity. Not once, but twice in a 5-year period. I got the first crack -2 amendment and second for the drugs -2. I come before you today as a proponent for retroactivity in a proposed criminal history amendment. Retroactivity may be the only possible relief for men and women that are serving lengthy, unjust prison sentences due to their criminal history. I want you to know the man I am today. I am a husband of a beautiful and amazing wife. I'm a proud father of 4 beautiful, intelligent daughters and an amazing son. In January of 2000, I became the world's happiest grandfather of a little beautiful girl. Excuse me, y'all. Sorry about that. On October the 20th of 2005, I was sentenced to 235 months in the Federal Bureau of Prison. I remember it like yesterday. On November 14th of 2005, I arrived at Greenville Federal Correctional Institution in Greenville, Illinois. I remember walking into the prison and thinking to myself, I'm going to be a better person for my family once I'm released from this place. Being sentenced to do 2 decades in prison, including for actions I had already paid my debt to society for, was mind-boggling. During my incarceration, my younger sister passed away from cancer. Excuse me. I never had a chance to say goodbye. 9 years later, I'm still suffering with this daily. I often think back to numerous motions I filed pro se due to and subsequently all denials. 4 years into my sentence, on February 3rd, 2009, I received my first 2-point reduction due to the crack -2 amendment. That was later included retroactivity. The amendment allowed me to give back the 84 months off the 235-month sentence I originally had. After additional years of legal work and persistence and patience, finally I reaped the harvest of my dedication. On December the 2nd of 2014, I received a second 2-point reduction as a result of the drugs -2 and the retroactive amendment. What a blessing. Because of retroactivity, I was given a second chance to live. It allowed me to spend a year with my mom before she passed away. The retroactivity turned years of hope into a reality and the opportunity to give back to the community I once committed crimes against. In 2016, 1 year after my release, my wife and I started a logistics company. In this next chapter of our lives, our goal is to start a trucking school. And in my spare time, I mentor returning citizens and small business startups so they can too be successful in their second chance. I am also an advocate for census reform and recently participated on Capitol Hill Lobby Day featuring 70 formerly incarcerated people and their loved ones. I had the opportunity to visit Senator Durbin's reps, Kelly, Bunzinski, and Snyder's congressional offices to tell my story. Retroactivity permits people's sentences under the guideline range have been lowered, chance to make their case to the court that they deserve a reduced sentence. Because the commission made crack and drug amendments retroactivity, I was able to tell Judge Barbara Crabb that I was deserving of those chances too. She believed in me. And in my rehabilitation, without retroactivity and her faith in me, I would not be here today. I'd be in prison with the release date 2 years away. No words can describe what it means to see the commission not only lower sentences that were too long, but also to do the right thing by making sure that people serving those sentences like me got a chance to prove they deserve a lower sentence. Those changes restore hope, and making the criminal history amendment will also give people the opportunity to return home to their second chance. Thank you all.
Thank you, Mr. McReynolds. I turn to my colleagues, see if there are any questions. Commissioner Gleason.
Thank you, Chair Reeves. It's not so much a question as an expression of gratitude that you're here. We hear from many stakeholders and many folks who deserve to be heard to influence policy, but none of them can do what you've done today in the content of your testimony and by your presence. And what I think it's, from my perspective, what you've done is place in the clearest possible relief three things. One is, just because someone's committed a serious federal crime, and I'll bet none of you would deny that you committed a serious federal crime, it doesn't mean you can't get a grossly excessive sentence that shames us all. The other thing is, the degree to which, related to that, is anybody who thinks that those grossly excessive sentences don't get meted out just hasn't been hanging around federal courtrooms the last 30 years. The second thing you place in the clearest possible relief is just because folks are serving excessive sentences doesn't mean they can't transform themselves in prison into completely admirable people. And anybody who thinks otherwise has no idea what people are capable of. And you, just by being who you are, prove that. And I think the third thing that you place in the sharpest possible relief is how important it is for policymakers, judges too, but for policymakers to consider all the other things we consider, the data, the stakeholders, but to never lose sight of the fact that on the receiving end of the sentences are three-dimensional human beings with families who love them, communities who need them. And I have a colleague at NYU, Brian Stevenson, who says if you really want to know an issue, you got to get proximate. And what you do is you bring us proximate to the results of the decisions that we make. And as far as I'm concerned, we can't thank you enough. Thank you, Chair Reeves.
Mr. Wroblewski, Commissioner Wroblewski, excuse me.
Thank you very much, Mr. Chair, and thank you all for being here and for your testimony. Mr. McReynolds, I just want to share my condolences about your sister and your mom, and Mr. Gibson about your grandparents. Mr. Breaux, you talked a little bit about the fact that there was a time in prison when people did not take advantage of programming, and there was another time when people started to take advantage of programming. Could you describe a little bit about what changed, what brought about people participating more and taking advantage of the opportunities? And also, if any of you can talk a little bit about what happened when you went home, what kind of interactions you had with the probation service, probation officers, supervised release, both positive and negative, about what worked and what didn't work.
In relation to your question on education and what changed, honestly, there had been so long a period of time where guys such as myself who were serving life sentences had absolutely no way of getting out of prison. In fact, we're familiar, and I don't know if anyone on the panel is, we do a biannual review. It's called TEAM. For lifers, there's on that sheet of paper that we get, there's a section on there that answers the question, your months to release. And when I was first incarcerated as a lifer, that answer was deceased. Sometime later, the people who put that answer in there realized that it had negative effects, and they changed it to 540 months. But I did 20 years. The first 10 years, it stayed 540 months. So it wasn't much better than deceased. What changed was, honestly, and I worked in the law library for many years and discussed law and read law. There were 20 years, almost exactly, from 1989, from 1979 to like 1999. And Apprende was the huge case that came out where there was some change. And people started getting relief. Lifers started getting relief. And they started noticing that the lifers that did get the relief were the guys that were taking advantage of the education or opportunities that were there. And it created, like the famous book, a tipping point, where more people would take advantage of the educational programs, more people would get relief because they participated in the education. Whenever there was a change in the law that people could be reviewed again by a court, education, rehabilitation was the focus. And so people started, inmates, I should say, offenders, I don't know if they use the word inmates, I'm sorry, but offenders in there were taking advantage of the educational opportunities, not just to get the benefit, but what they realized was they were changing. They were becoming better people, better parents, better children. They were apologizing to family members that they had let down. And so that's when it changed. When you start seeing somebody get relief, and why, you ask, why did they get it? You're reading the opinion written by the judges. Education was always there. Rehabilitation, those were watchwords that were there. and we took advantage of that.
I also want to add to that too. Not he's exactly right, but also the programs that they have are very limited. When I was in one facility, I think it was 1,200 people on the pound, and I actually taught the cabinet making class. I finished, and I ended up being a teacher and one of the instructors in the class, and it'd be a waiting list to get in. And for someone that has so much time, like you said, I think you said it before to me about if you had life, you get to the back of the waiting list. And so it's hard to even get into these classes. They don't have enough of them. And, you want to do it, but, you're looking at, like you said, 300-400 months. And they're telling you each time you can't get in. What do you do? And it's just hard to even maintain when you don't have anything, because they really don't. I think the class I was in, we had maybe 8 students, at a time. And each class was maybe a few months. So if you had, I was on that particular pound for 15 years. And not many students were able to come through, and a lot wanted to come, a whole lot. Because I was an instructor, they would ask me all the time, Bernard, when can I get in? When could we? It's not like they don't want to. There's so many people, I've been around so many guys in the facility that I've learned so much from. Oh, I've learned a lot from these guys. And people change. And people realize the mistakes they had. I even had one class that they took us out when I finally got to the camp before I came home. And they had a program called Back to Reality. And they took me to VCU. They took me to Fort Lee. They took me to all the courts to talk to the youth, to talk to the military people who had gotten into some type of trouble. And the panel was really diverse. It was a really good panel because every walk of life was in the panel, from drugs to one guy had burned something up. It was just a big diverse. So the purpose was to show that anybody could make a mistake. Anybody could turn left or turn right and end up in jail. And with that panel, it really got me to where I wanted to be today with the kids. Because when the first time a kid came up to me, and we weren't supposed to touch the kids or anything. One kid came up the first kid came and hugged me and cried. And it really showed me that, we can make a difference. And they can really, and me with Lead for Life now, they can really relate to when you've been through what they've been through. Like you said, putting a face to it. I think we make decisions on different things, but to put an actual face and a person to those decisions makes a big difference. And to answer your question, a lot of times they just don't have the opportunity to do it. I even got my CDL license when I was incarcerated. They didn't even have a class. You had to do it on your own. We studied. They had a truck. They allowed us to, I was at the camp, they allowed us to go around the facility at the camp, and they took us to, I had my license when I came home. But it was only a certain amount of people that can do it. So it's not like these guys are sitting in there not wanting to do stuff. It's nothing sometimes for them to do. And if you don't have family, because of, I was turned down because of Apprendi too. Actually, my dad's name is on Apprendi. Bernard, if you look, his name is on there. And when I got turned down, it was hard because I'm saying to myself, I've done everything. I've taken every class. I'm teaching. I have. You can ask anyone at the facility about me. And I get a letter stating that you're absolutely right, but because of retroactivity, you don't get it. That's hard. And if it wasn't for that grandmother telling me, baby, hold on. God has something else for you. If it wasn't for Melbourne and Mike and Christy coming to see me, and a lot of these guys don't have this. I've seen guys 10, 15 years not getting one visit. I've had arguments because my family was so close to me with councils because I had too many people on my visitor list. I said, isn't this rehabilitation? This is what you want, right? I've literally had to they had a grandfather clause. I had to go get my grandfather clause to prove that I can have these on my list. They cut it down to 10 people. What if you got, I grew up in a household, my mother got 9 sisters. My mother was 15, she was like my sister. So her sisters are like my sisters. So you're telling me that the person that raised me, that took care of me, can't come and see me, but you want me to be rehabilitated? It's hard. It's hard. And you guys have power to make change, to really help someone who really, if you've known them and see them, see that they need it, see that they deserve it. And I understand the victims. I understand it. And I know so many guys that are so remorseful for the things that they've done. But you're a product of your society. And the same thing with incarceration. If you don't have nothing for them to do, then what do? They get into more stuff. It's not like they're not trying to change, but it has to be an avenue for change. If there's no avenue for change, how do we have change? I don't want to talk too much. I don't want to take up his time. But just, it's personal to me.
I'm going to talk to you about the U.S. Probation Department, and when I was released, it was real hard financially, because they told me I couldn't go home. I'm married, I was married while I was incarcerated. I was supposed to move back to Huntsville, Alabama, and I could say the name. The young lady there, the probation department, her name is Candy Cheatham. She told me I couldn't come home. So she said I had to go back to where I was originally arrested. So I had a home in Huntsville, Alabama, and my wife had to take out a $90,000 refi on my home to come to Chicago and build another home for me. So now we have two homes. I had to uproot my children to move them to Chicago. And we have to maintain all this just for a few months until I'm actually under a probation officer, which was November the 1st as it came around. So they have all these things in your way, like if you need to go grocery shopping or to any store, or you have to have an itinerary. You don't know in life, you don't know what store you ever have to go to. So how can you set up a schedule to go somewhere? What if you need a hairbrush or a comb or anything? So it doesn't matter. Like, you have to have an itinerary in order to move around. And you're supposed to be out, but it's like you're not out. So you have to adjust to all these rules, and it really affects you. Like, it's like, wow, I should have just stayed in prison. Like, I know you heard this thing, people say, I'm gonna go to jail and I'm gonna do the whole 6 months and I'm just gonna stay. I don't wanna be on no supervised release until this time, you know what I'm saying? So the thing is, the woman didn't want me to come to Alabama at all. So I waited until the period, it was 6 months I had to wait. But my wife had to come and build a home months before that. We had to have landline phones. I don't know how many people have landline phones anymore. It's a hard thing. Who answers the house phone? You got a cell phone in your pocket. So they want a landline. They call you numerous times of the night. If I wasn't fortunate enough to have a support system with transportation, they'll call you 2, 3 in the morning and say, you need to come down here and take a UA. What if I don't have transportation? In the city that you said this is violent, now you have to cross over all these neighborhoods to get to somewhere on public transportation to take a UA. It doesn't make any sense, man. It's hard. It's hard on our families. It's so much, but I'm gonna go. That's the bad side. But the great side is I met a great probation officer. His name was Andy Islage. Helped me so much. Like, he should be the poster child for probation officer. So he was cool with my career. He made it work. Like, I had to go over the road, which most probation officers say you can't leave a certain amount of radius. But he said, all you got to do is keep me with an email chain, let me know where you're going. And then just send me your financials in when you're done, which he went above and beyond. I got so far into working, the email chain was so long, he said, Jeff, just don't, you got to stop. He said, I know you're working. So real great man. He actually left the the office down in Huntsville and moved over to Florence, somewhere in Alabama. But it's great people out there, and it's people that need a little work. You know what I'm saying? I don't like badgering people or nothing like that, but it's the point. You know, you got some gems out there, and you got some coal. So you got to just, you know, it's good and bad. So, no, thank you. I don't want to go on.
Excuse me, if I may, I would be remiss if I did not mention my probation officer. Her name is Alicia Sturgis, and she was fantastic from the first day we met until I was released from supervised release. And even to this day, I still communicate with her. She's probably watching this. If not, she's got a link to watch it because she wants to watch it. She told me when I emailed her about it, I'm telling everybody in my office. And it's a great feeling to know that, and we all share this, that there are people that play a role in the process, the probation office, the U.S. Attorney's Office, the Federal Defender's Office, that they are aware that we are contributing, we are productive, we did not reoffend, and we are growing in a positive way.
Right.
It means a lot to us that I mean, outside of our nuclear family and friends, we actually care that you people, the people like you, the policymakers, the people who have those jobs that come in from work sometimes because they had to deal with somebody not like us and go, we care that you know that we're out here and we're not a problem. It means a lot to us.
It meant a lot just to be asked to come here. I didn't even know that we were able to even speak, just for you guys just to hear us out. You know, because like I said, it's a big thing to put a face to it. And I know there are a lot of pros and cons, but you see the table here is pros. I don't have any cons when it came to retroactivity. Everything worked out for me, you know, same with the probation officer. The first day he came and met me, we talked, he told me what he wanted, and we had a conversation. We talked maybe for an hour and a half. And what he said, when he left my house, he shook my hand, he said, I don't see any else having any problems. And we didn't have any problems. And I'm telling you, I'm in touch with a bunch of guys. The funeral I just went to was a guy that keeps everybody together. And he accidentally got killed. It was an accident. And it's a bunch of guys there. I'm talking 40, 50 guys. Mike was there. And these guys come together all the time, keep each other up. You know, I told one guy, I said, man, I ain't Dr. Phil. Don't call me for everything. But we look out for one another. It's really a family because, you know, I never understood when he said you can't talk with when you're under probation, or that you shouldn't talk with other guys that were incarcerated. So you mean to tell me I'm 27 and I go to jail and you give me 27 years. I've been with this guy 18 years. We had each other's back. You know, when I needed a few dollars, he gave me. When he needed a few dollars, I gave him. We looked out for one another for 18 years. But I can't call and say hello. This is who I'm with. This is my friend. This is a person that we grew. This is maybe the person that got me to change. Because I know I've changed a lot of guys. I take credit for it. I do. I see them to this day, some younger guys that grew up in jail with me. And now they're home doing the right thing. They're all working. I don't know one person that I was close to, and I was close to a lot of guys because I did a lot when I was in. I taught the class, I refereed the games. I'm known in the system where I was at. These guys are not going back. They're just not. And they're very productive. I'm talking, you know, I got one buddy who owns 40 dump trucks. He's a multi-millionaire right now. So it is wrong to say that people can't change, because I've seen it over and over and over again. And I can only tell you from what I've seen. I don't know all the statistics. I don't have all the graphs. But in my community, these guys have changed. They're not going back. And for all of us that I know of that got this retroactively applied, I don't know not one that had a problem.
Good afternoon. I just want to thank each and every one of you for your testimony. I read your materials. They were extremely moving and compelling. Throughout, there was a thread throughout each of your submissions and your testimony today that, while you were incarcerated, you had hope that you were going to get out. Notwithstanding, I think you threw your first 2 letters in the trash, you said, and you didn't even open them from the federal defender, I believe it was. And because you just, at the time just thought, well, this is just something else that is not going to end up as, fruitful. But you each had hope along the way, and you each engaged in a lot of programming. And so, my question is, what can the Bureau of Prisons or we do in addition to, I understand your position on retroactivity, but what can we do within that system to inspire more hope? Is it additional classes? Is it, what can we do to affect, and produce more folks like you who are, you're telling us are already there?
Right.
What are the tools that they need to succeed?
Well, first and foremost, we got to understand that a lot of these guys never had jobs. They never had the opportunities of family or I mean, one guy who was, they used to call him can't get right. He literally can't get right.
Oh.
But how do you get right when you literally was on the street since you were 5 years old? He didn't know his mom. He didn't know his dad. I mean, he literally was on the street. I'm talking literally. And when people would say things, it used to get me mad when they would, say little things. And I was like, you never been in his shoes. So the opportunities just to even have change. I taught a class how to tie a tie. These were grown men that didn't know how to tie a tie. So you're looking at people who didn't know any better. If you keep, doing the same thing, you're going to keep getting the same results. Unless you change. I said it to one of the young ladies back there. I said, my dad was on my case too. And I grew up in a time where they were really in the streets and I knew a bunch of people. And I said to her, if my dad was a carpenter or a plumber or a mechanic, I probably would have been one of those things too. So you're a product of your society. So if there's nothing, like I said before, for you to learn to do, then you're going to be stuck. Then these are the guys that you're looking at that comes back because they didn't learn anything. I think that they need more programs. They need more funding for programs. They need more people to come in to talk to because I had a family and friends. I didn't need a visit. You had a lot of people that at one time they had a thing where people was coming in just to visit people, just to give them a visit. That matters. All of these things matters. And if you want to stop something, you have to change something. And if you put someone in for 20 and 30 years, you put a young man in at 21 and 22 years old, and it was many, because I thought my case like you. I looked at it and I said, wow, when I got in, I seen so many of them just like mine. And I'm like, wow, these young guys got all this time. And it gives you a different perspective. And I'm talking about guys that don't have no resources, none. Even with the CDL class, a lot of guys wanted to take it. They didn't have the money to pay for it. So there's a lot of things that needs to be implemented, especially educational, to get them ready to be able to do some things. And not just them doing it themselves, because a lot of stuff I did myself, and I was blessed. I had a praying grandmother to get into these programs. But they need more programs. They need more help to teach and to show in many different ways, writing skills, educational skills, GEDs. I was surprised to see so many people that didn't have a GED. And you wonder why these people are doing the things that they're doing. They have no other way sometimes. They need better ways.
Yeah, I say the same thing. The education department can be expanded, like with more programs, probably a little more staff as well, because you have certain programs in where I was in Greenville. They had Greenville College coming in and doing certain programs. They have a culinary program which is small. You have the trucking, the CDL classes. You had college courses, but you had to pay for the college courses yourself. But most of the people in education that work in education, staff that work in education, they did become proctors to us though. It just needs to expand because they only have room for so many. Like if you have a class that you only could run, what, 8 times a year, and you got 1,200 people on the compound, you only could fit 10 to 12 people in the class. So that's not really, it ain't even scratching the surface. And people coming in every day, like, but people not going home every day.
I think, other than education, to your point, BOP has something in place for every negative situation. They have something in place for every possible negative, every disciplinary action. And one of the worst is called a step-down program. Like if you are at a low-level security facility and you do something, violate the rules, their discipline is to send you up in security. And then you step down. Once you've proven that you could conduct yourself accordingly. I think that needs to be applied in a positive way. I was in Terre Haute USP with 2 life sentences, and the unwritten rule was nobody with a life sentence could transfer to a medium security facility until they've served 10 calendar years. That was the unwritten rule. It was nowhere in a book. No counselor could point to it in a manual, but if you had medium security points like I did, hey, you tell me come back, you don't have 10 years. Until I started taking every single possible class, until I started making relationships with the staff and education, speaking with the assistant warden of education, who later went on to become a warden, and he's probably working in the region, if I can remember his name. And in fact, he would come through on tours. I left Terre Haute, he came through on a tour in Pekin, I saw him there. I left Pekin, I was at Rochester FMC, he came through on a tour and I saw him there. He would always make a point, if I saw him, he'd stop me, we'd speak, and it meant something to the staff for him to stop and speak to me. But I think what would really help and what would incentivize more people to engage in these educational programs is that despite what your sentence is, your sentence length, if you show change, positive change and growth, then that carrot becomes a transfer to a lower level security facility, not for the security aspect, but at these lower level security institutions, the educational programming availability widens. When I was at Terre Haute, there were some, and I moved down to FCI Pekin at medium security, there were more. I moved down to Rochester, which was technically a low, and there were even more. I was able to acquire a forklift driving license using the forklift in the warehouse. They had apprenticeships in plumbing, electrical, HVAC. I know people right now that were released after 15 plus 20 years that are licensed master electricians. I still stay in contact with these people all over the world. I know 3 of them in Minnesota alone, 2 in California, 1 in Iowa. Through that program. That's a 5-year program. And they were able to not only participate, they were able to complete it, and they are all fine, upstanding, productive members of society. In fact, if you lived next door to one of them, you wouldn't know they had ever been in prison unless they told you. Some of the people that I know, I would go out on a limb and say most. If we could afford it, you wouldn't mind having us as a neighbor.
Any other questions or comments? Gentlemen, thank you so much for your testimony today. It is archived permanently on our website, www.ussc.gov. Show those kids that you're inspiring back home in that For the Life program. And everything else where you're dealing with these young people, even back at the people who you know, who you left behind. They can go back and watch it as well. So please tell them they need to hear your story. With that, I would like to bring our hearing on retroactivity to an end. On behalf of my fellow commissioners and my friends here at this table, I want to again thank each of our panelists who came before us today. I want to thank the members of the public who sent in comments on this subject. I want to thank all those who have participated in any way possible, especially our staff. I want to thank all those who have taken the time to listen in. We've heard powerful testimony today. We will consider that testimony, and we will use that testimony to make sentencing policy that we believe is right, that is fair, and that is just. With that, this hearing is now adjourned. Thank you.